Okay, we're all set.
All right. Well, good morning, everyone. I'd like to call to order the Judiciary Public Hearing for March 4th, 2022. This is our first substantive public hearing on substantive bills, I should say, for this session. I'd like to just briefly remind both members of the public and members of the committee about our process. We do have a pre-assigned sign-up list. There is no set reserved first hour for public officials anymore. So we will jump right into hearing from folks. Remember, everyone has 3 minutes to give a statement, testify before the committee. I would encourage members of the public to not read from written testimony. The written testimony is available to the committee. There's no reason to read that into the record. Simply a summarization or make any points, emphasize any points that are not in your written testimony would be appropriate. After the 3 minutes, you will see on your screen a hand go up from the timer that will indicate your 3 minutes are up. If you don't wrap up within a sentence or so of that, the chair will ask you to conclude so that we can get on to the next member of the public. We do have a relatively robust list of signups today. I think we have nearly 60 people signed up to testify. So we will try to keep this moving. I would also ask certainly members of the committee, if you have questions, please try to keep those as succinct as you can, and do not duplicate questions that have been asked by others. I see my co-chair has joined, Senator Winfield. Anything to add to that?
Just good morning.
All right. Good morning, Senator Kissel. How are you?
Good morning. Great. Good to see you two chairs, and I'm hoping we can be expeditious today.
It is a Friday, so we will try. All right. With that, we will start with the first person I have signed up is Olivia Rinks. Is Olivia Rinks with us?
I know, Mr. Chair, so much comes down to how often I talk, so I'm going to try to keep it on the downside.
I wasn't specifically addressing you, Senator, but take the comment as you will. All right. Is Ms. Rinks with us, Madam Administrator? I don't see her.
It is not.
Okay. How about Ed Hawthorne? Is Ed Hawthorne with us?
He's just joining now.
Okay. Ed Hawthorne will be our first person.
Thank you.
Good morning, Mr. Hawthorne. When you're ready, you can begin. You have 3 minutes.
Thank you. Good morning, Representative Sastrom, Senator Winfield, and members of the Judiciary Committee. My name is Ed Hawthorne. I'm proud to represent working men and over 200,000 working men and women in Connecticut as the president of the Connecticut AFL-CIO. And I thank you for the opportunity to testify today in strong support of Senate Bill 163, an act protecting an employee freedom of speech and conscience. Imagine you are a housekeeper in a large hotel chain. You are a female, legal, permanent resident with limited proficiency in English. You and your colleagues, anxious for better wages and a more reasonable workload, have begun the process of forming a union. In response, your employer hires and dispatches teams of anti-union consultants into the hallways. Without warning, 4 men come into a room you are cleaning, close the door, and begin asking you questions in English about your desire to form a union. They raise their voices, they block the door. When you tell them why you want to join a union, they threaten your job and your immigration status. You feel afraid, cornered. You have no protections, no voice, no choice but to endure this captive audience meeting. This is not something that I'm making up. This is what happened to several housekeepers in Stamford, and their experiences are not that different from thousands of workers in the state of Connecticut. As my testimony states, and I will summarize, I promise, Representative, the United States Supreme Court has recognized it as a form of coercion to make people listen, and that no one has the right to press even good ideas on an unwilling participant. Captive audience meetings are mandatory closed-door meetings that are held during work hours. Often they're filled with lies and half-truths meant to change a person's mind about joining a union or any sort of political or religious policy. This is something that happens frequently in Connecticut, and it is outlined in greater detail in my testimony, but some recent examples include Glambia Nutritionals, Dollar General, McDonald's employees at the Service Plaza in Darien on I-95, Apple Rehabilitation Nurses in Waterbury, the town of Newington, Hebrew Senior Care Workers in West Hartford, Foxwoods Casino Environmental Service Workers, Becton Dickinson and Company Manufacturing Workers, Severance Food Workers, Stanford Hilton Hotel Service Workers, Stanford Sheridan Hotel Workers, non-professional employees at Danbury Hospital. This bill before you does not restrict an employee's free speech. Rather, it allows an employee the right, when the subject of a meeting is about employer's position on politics, religion, or labor organizing, to stop listening, walk away, return to work, and not participate without fear of being disciplined. Now, we've been talking a lot about union organizing, but I do want to highlight the political speech version of it as well. In Connecticut, health insurance giant United Healthcare Group pressured its Hartford rank and file employees to mobilize against legislative efforts to create a state-level public health insurance option in 2020. The Vice President of External Affairs instructed
Mr.
employees.
Hawthorne, you're at the 3-minute mark, so if you could
Well,
just.
I thank you for your time and your opportunity and the opportunity to testify here today. I'd be happy to answer any questions that you all may have.
Thank you. Questions from the committee for Mr. Hawthorne. Mr. Hawthorne, just real quick, I know this is obviously a bill that we have heard several years in a row, and often the debate on it centers on the issue of preemption. Could you just very briefly summarize the AFL-CIO's position on the preemption issue?
Well, the AFL-CIO's position on it is the same as the Attorney General's position, that it is not preempted by federal law, and that is materially different from prior bills that have come up before the committee. I believe, and I think I saw there were multiple labor attorneys that were signed up, and I would ultimately defer to the Attorney General's expertise on the subject and his willingness to submit testimony on the subject and willingness to defend any lawsuit that may come about it. But we do not anticipate it being that, because it like I said, it's different. It's a First Amendment right, and it's something that the state has the right to do and regulate the workforce.
Thank you, sir. Further questions or comments from the committee? Seeing none, we appreciate being with us this morning.
Thank you, Representative. Have a great day.
You too. We will next hear from the Senate President, Senator Looney.
Good morning, Representative Safstrom, Senator Winfield, members of the Judiciary Committee. I'm Martin Looney, Senator from the 11th District, and would like to express my support for Senate Bill 163, an act protecting employee freedom of speech and conscience, and also House Bill 5210, an act concerning forgery of a written instrument indicating vaccination against COVID-19. On Senate Bill 163, Mr. Chairman, I believe that employers use this form of meeting, a captive audience meeting, where employees are herded into a room or other location and forced to listen to anti-union speech, because among all the means of communication available to employers, this one is the most coercive, the most unsettling, and the most intimidating. And that's why it's used when they can get away with doing it. And I think that's why we need to oppose it strongly this year. And I think the Attorney General Tong's opinion has shown us the path to do so in a way that will not run afoul of the National Labor Relations Act. And the legislation would protect an employee from economic sanction if the employee chooses not to listen. That's one of the issues. There is a right not to listen to an employer's political or religious view. And it is important that the freedoms and the protections that workers have include the right not to assemble and the right not to listen to coercive speech. That's what this is all about. The bill has been introduced a number of times. I've sponsored it a number of times. I certainly hope that this is the year that we can get it across the finish line as a matter of labor justice. Often these meetings are conducted in the most intimidating way possible. At a news conference this morning before this committee hearing, there were statements made by people who were put into a room and company employees stood and blocked the door, that they could not even leave. They were required to stay for the entire presentation. This bill would allow people to get up and leave freely and be free of coercion in doing that. And I think that Attorney General Tong has certainly shown us the way to do this in a way that won't run afoul of the National Labor Relations Act. And he has pointed out in his May 2019 decision that the bill that was proposed that year, which is identical in the most important respects to this year's bill, is very different from the bill that former Attorney General Jepsen indicated might have been problematic in 2018. So again, as a matter of labor justice and a matter of recognition of the state's right to use its police power, the Connecticut General Assembly and the courts have a long tradition to support the use of the police power, the state's police power, to protect employees from coercion in the workplace and to protect privacy interests. And this bill stands in that tradition, so that a worker does not relinquish all of his or her First Amendment rights merely because he or she happens to be in the workplace. And the state can and should offer these protections to employees. I would also like to add briefly that Senate Bill or House Bill 5210 simply ensures that altering a COVID vaccine card will be punishable as forgery. And this would seem to be a common sense addition to our criminal laws, since people need to be able to depend upon the accuracy of the information contained in those cards when they're in the company of people who claim to be vaccinated. Thank you, Mr. Chair, members of the committee. And I want to again commend this committee for all of the important work that it does each and every year on issues of critical importance to the people of our state.
Thank you, Senator. Questions for Senator Looney? Questions for Senator Looney? Seeing none, Senator, I know you probably have a busy day ahead of you, so appreciate you taking some time with us this morning.
Thank you again, and I hope your day won't be too long on this Friday. Thank you so much.
Next up will be Shelley Davis.
Good morning, Senator Winfield, Representative Staffstrom, and members of the committee. My name is Shelley Davis, and I'm proud to serve as the Executive Vice President of the Connecticut AFL-CIO, a federation of hundreds of local unions representing more than 200,000 members. Our members live and work in every city and town in our state and reflect the diversity that makes Connecticut great. Thank you for this opportunity to testify. Unions help bring workers into the middle class on average. Workers join together to bargain wages, hours, and working conditions, earn higher wages, utilize fewer safety net services, have greater productivity, and experience less turnover than non-union workers. Yet when workers try to form unions, employees routinely respond with campaigns of threats and misinformation. In theory, federal law protects workers' freedom to form a union, but in reality, workers struggle to maintain this basic right when they are being inundated with employer harassment and intimidation. SB 163 protects a worker's fundamental right of free speech when employers misuse their authority and require employees to listen to management's views on matters of individual conscience. This bill simply allows an employee to leave an employer-sponsored meeting and return to work if the meeting is about religious and political or unrelated to his or her job performance. When facing with a union organizing drive, most employers hire union avoidance consultants to orchestrate and implement anti-union campaigns. These so-called persuaders help employees keep their business union free. This provides anti-union talking points, flyers, videos, and other services. In short, an employee may hold any meeting they want. They can say what they want. SB 16 in no way prevents employees from discussing religion, politics, or any other subject. SB 163 only prohibits employees from firing or disciplining employees who leave the meeting because they do not wish to listen to the employer's view on such topics. I implore this committee to allow workers the freedom to make their own decisions about forming a union from employer harassment and intimidation. We urge you to act favorably on SB 163. Thank you.
Thank you. Questions for Ms. Davis? Questions for Ms. Davis? Seeing none, we appreciate you being with us this morning. Have a good day.
You as well. Thank you.
Oswaldo Chin. Oswaldo Chin. Annie Dance. Annie Dance. Joseph McAlarney.
Good morning, Senator Winfield, Representative Staffstrom, distinguished members of the Judiciary Committee.
Sir, I don't, your camera's off. I don't know if you want it on, but we can't see.
I'm setting it on.
There you go.
Better. Again, good morning, Senator Winfield, Representative Staffstrom, and distinguished members of the Judiciary Committee. My name is Joseph Malcarney. I'm the business manager at IBW Local 420. I wrote this testimony as an advocate on behalf of the 600 plus essential electric, gas, and water utility workers positioned as first responders in the past, present, and future of my local. I'm here to testify in support of SB 163, an act protecting employee freedom of speech and conscience. I have helped workers form unions over the last 17 years, and what should be a simple yet empowering democratic exercise for workers is more often a long, complicated, and risky endeavor. Workers often endure the employee's use of threats, surveillance, and intimidation when seeking to form a union. Thank you for holding this public hearing to allow us to speak on this matter. One of those most widely used techniques of employer harassment and intimidation during unit organizing drive is to schedule frequent mandated closed-door meetings during working hours, known as captive audience meetings. These captive audience meetings are usually billed as informational sessions, but the boss and their hired union busting consultants deliver misinformation, make false representations, and issue threats attempting to issue fear, instill fear. Employers often tell workers that if they vote for a union, they will have to cut their hours or pay, or may even have to close the workplace. Some have told workers their immigration status could be jeopardized. They almost tell the workers that the union will charge them exorbitant membership dues and desert them once the election is over. Many workers leave these captive audience meetings shaken, sometimes crying, worrying the manager will retaliate if they refuse to attend future meetings or vote in favor of a union. It's easy to understand how workers can feel so frightened and overwhelmed. Just last week, I had to withdraw a petition to organize workers at Aquarian Water. I had to withdraw because since the day I petitioned the National Labor Relations Board, the management at Aquarian held these captive audience meetings. They used every dirty tactic they could come up with. They hired an anti-union consultant from Kentucky. They brought in another smaller union that they control to speak negatively about the IBW. They held at least 2 meetings a week, even paying people overtime to stay for these meetings. In these meetings, they told employees that, they told one of the ringleaders that if he makes this all go away, then he'll be okay. In my eyes, that was a threat. They told the workers if they voted to go to union, they would lose their pensions. They told the workers at Aquarian, if they voted the union, they would close the Stanford building and make everybody report to the Bridgeport office. And they confused the workers, saying that if they join a union, they start with this, while holding up a blank sheet of paper and saying, you get nothing, which is a lie. They get status quo. They told the workers if they weren't state licensed, the union would demand them to be terminated.
Mr. McCullarney, we're at the 3-minute mark, so I just need you to summarize.
All right. So I'll just, I urge the committee to protect the workers' constitutional rights by passing SB 163. Thank you for the opportunity to testify.
Thank you, sir. Questions or comments from the committee? Questions or comments? If not, thanks for being with us this morning. Kevin, Senator Kelly with us. Senator Kelly. All right. We will go on to Beverly Brakeman. Beverly Brakeman here. Okay. Brooke Foley.
Good morning. My name is Brooke Foley. I'm the General Counsel of the Insurance Association of Connecticut. The IAC represents Connecticut's property and casualty insurance industry and Connecticut's life insurance and financial service industries. The IAC would like to testify today in opposition to Senate Bill 163 and House Bill 5235. The IAC opposes Senate Bill 163. As you know, the insurance industry is one of the largest employers of the state and it's vital to the state's economy. This bill is problematic to employers. First and most importantly, it's preempted by federal law. It directly conflicts with the National Labor Relations Act, which protects the rights of employers to discuss political matters, including labor issues, with their employees. If the bill passes, employers will be prevented from requiring their employees to attend meetings or read communications that may be necessary to the employer's business operations, such as how a particular piece of legislation might affect business. It also would lead to an undisciplined work environment where an employee might decide that any particular issue is political, for example, diversity training or mask wearing, and choose to disregard his or her employee's direction to attend necessary training or read communications, leaving the employer with no way to take adverse action against the employee. The IAC also opposes House Bill 5235. This bill will increase costs for Connecticut businesses, insurers, and residents. Prejudgment interest is awarded to a plaintiff in addition to money damages if a settlement offer had been made and rejected before trial and if the case is ultimately decided in plaintiff's favor. It's meant to encourage pretrial settlements and conserve judicial resources. However, it effectively punishes a defendant for pursuing its right to a trial rather than accepting a settlement offer. Because it's part of the damages awarded in a case usually paid by the defendant's insurance carrier, prejudgment interest further inflates the amount paid by insurance companies. The current statute computes interest based on the date the plaintiff files the offer of compromise. This encourages the plaintiff to offer to settle early in the process and furthers the state's goal of judicial efficiency. Under the bill, the interest begins accruing on the date of the injury. This would actually decrease the plaintiff's incentive to file quickly an offer of compromise because the plaintiff can even file at the last minute, years into the suit, and still collect interest from the date of the injury. It also allows the interest to begin accruing before the suit's even filed for the entire statute of limitations period. So the defendant might not even know about the injury and still be on the hook to pay that interest, as well as the interest that accrues from the date of the claim to the date of the judgment. Calculating prejudgment interest from the date of the injury results in an extremely long interest period and could amount to an unfairly large amount of money. This will exorbitantly increase the costs and the amount of damages and cost to businesses and insurance carriers, which ultimately will result in increased premiums and costs to state residents. We urge the committee to reject Senate Bill 163 and House Bill 5235. Thank you.
Ms. Foley, you started your testimony by fairly definitively saying, I guess at least in your opinion, that the Senate Bill 163 conflicts with the Labor Relations Act. You're aware that the Attorney General has testified just the opposite to that, correct?
Well, the Attorney General's letter that he provided said that he stands in support of the original opinion that was written by the previous Attorney General. And so our position still is that it's in conflict with federal law.
Okay. Further questions or comments from the committee?
You skipped a lot of people, like they must be
having. Further questions or comments from the committee? If not, all right, I see Ms. Brakeman was able to get in, so we will go to her next. Thank you, Ms. Foley, for being with us. Beverly Brakeman.
Hi, thank you so much, Representative Stathstrom and Senator Winfield. My apologies, there was a panelist link that came in a little too soon before the next speaker. So thank you so much for this opportunity to speak. My name is Beverly Brakeman. I'm the director of UAW Region 9A. I'm here today asking for your support of Senate Bill 163, an act protecting employee freedom of speech and conscience. Despite the fact that 68% of Americans approve of labor unions, the highest Gallup poll rating since 1965, when it was 71%. Forming a union takes enormous courage, strength, and the willingness to take on your employer. It is the rare employer that welcomes a union. There are consultants and lawyers with union-busting playbooks that even the smallest, least financially stable employers will pay lots of money to employ so they can effectively deter their workers from forming a union. One way employers do this is by what we call captive audience meetings. Meetings workers are required to attend and listen to all of the employer biased ways in which forming a union will hurt workers, their families, and their livelihoods. Employers have wide latitude to what they can tell their workers, and UAW members who have been subject to these meetings leave fearing retaliation and other actions against them for wanting to form a union. And workers are captive because often not attending and or speaking up in these meetings will jeopardize their employment and thus their livelihood. This bill addresses the power imbalance between employers and employees by creating a clear and narrow prohibition that bars employers from requiring employees to attend meetings or listen to speech concerning political and religious matters unrelated to job performance. In a state where the distribution of wealth is so marked, unionization can begin to level the playing field for all workers. We should be making it easier and more fair for workers to form unions. This bill will just do just that, and I urge your support today. Thank you so much for your time.
Thank you, Ms. Brakeman. For questions or comments from the committee? Questions or comments? Seeing none, thanks for being with us. Next, we will go to the Probate Court Administrator, Judge Beverly Straits-Kaflis. Judge Beverly, are you there?
I am. Good morning. Good morning, Senator Winfield, Representative Staffstrom, Senator Kissel. I don't see Representative Fishbein and distinguished members of the Judiciary Committee. I'm Judge Beverly Straits-Kaflis, Probate Court Administrator, and I thank you for the opportunity to testify this morning regarding Senate Bill 164, an act concerning state agency compliance with probate court orders. This bill has obviously come before this committee before and did ultimately, with revised language, was passed, but then subsequently vetoed in the last legislative session. So I offer at the outset that the probate court system understands and respects the important roles of state agencies, and we remain willing and interested in working with them to resolve statutory language to address the purpose of this proposal. I have submitted written testimony similar to what I have submitted in the past, and really merely highlight this morning for the benefit of the committee that this bill confirms existing law by stating that a state agency, like any other party to a probate court proceeding, is bound by the court's decision. It is also consistent with the Supreme Court decision in Valliere versus the Commissioner of Social Services. I know you have a long list of witnesses to come before you, so I will leave it with my written testimony and answer any questions anyone may have.
Judge Beverly, I'm sure you saw the governor's veto letter on this bill last year. I'm wondering if you want to comment on any of the points raised therein.
Certainly sensitive to the concerns of the state that this would not override the jurisdiction of any state agency, but conversely, what is important is that state agencies also recognize the jurisdiction assigned by the legislature to the probate courts. And that is really, I think, the crux of the dilemma that is being sought to be resolved with this proposal. The probate courts do not, nor do they entertain determinations for eligibility for any of the benefits that are ultimately approved or under the jurisdiction of the Department of Social Services or the Department of Developmental Services. And it's really a recognition of the distinction of what the judicial authority is, and that the state agencies within that jurisdiction should respect those decrees.
Thank you, Judge. Further questions or comments from the committee? If not, enjoy your Friday. Thanks for being with us this morning.
Thank you. Have a great day.
Next up will be Travis Woodward.
Hi, good morning, everyone. Senator Winfield, Representative Staffstrom, Senator Kistel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Travis Woodward. I'm a resident of Hamden and an engineer for Connecticut DOT. I'm also the president of CSEA SEIU Local 2001, a labor union representing over 23,000 state, municipal, Board of Ed, active and retired public and private sector workers. I offer the following testimony in support of Senate Bill 163. I'm a proud union member who was raised in a union household. My mother and father were both Connecticut state employees and members of CSEA. Growing up, I saw firsthand the power and value of workers joining together to form a union. Workers choosing to form a union should not have to endure a long, complicated, frightening, and risky endeavor. Unfortunately, that is too often what happens. In the process of forming a union, workers have to face their employer's use of threats, surveillance, and intimidation. The bill before you protects the fundamental right of workers to make their own choice to form or join a union and ensures that workers can make their own decisions free from fear of intimidation. You will hear a lot today about so-called captive audience meetings. This technique is often used by employers to harass and intimidate workers during a union organizing drive by scheduling frequent mandatory closed-door meetings during work hours. While these meetings are usually billed as informational sessions, in truth, they are an opportunity for the boss and their hired union-busting consultants to deliver misinformation, make false representations, issue threats, and attempt to instill fear. Time and again, when workers choose to organize to form a union, employers try to scare them by telling workers that if they vote for a union, they'll have to cut their hours or pay, or may even have to close the workplace. Some employers even tell workers that immigration status could be jeopardized. And they almost always tell workers that the union will charge them exorbitant membership dues and then abandon them when the election is over. Despite all of this being untrue, many workers leave these captive audience meetings shaken, sometimes crying, worrying that management will retaliate if they refuse to attend future meetings or vote in favor of the union. It does not take much to understand how a worker can feel so frightened or overwhelmed. This bill does not infringe on employers' First Amendment rights. Rather, it affirms their, sorry, I had a call there. I'm not sure if my video went out.
You're good now.
At any time. It does not prevent employers or anyone else from discussing religion, politics, or other topics. Senate Bill 163 only prohibits the firing of employees who leave the meeting because they do not wish to listen to the employer's options about religion or politics. It should not be acceptable for employers in positions of power to coerce workers for them adopting political position or religious belief by threatening their livelihoods. Events like this are bad for the democracy and bad for the workplace. Work should be about the job, not adherence to employers' political or religious ideology. When the first Continental Congress convened in 1774, the delegates met at a union hall, the Carpenters Hall in Philadelphia. And so all these years later, I encourage you to honor our nation's history and cast a patriotic vote in support of Senate Bill 163. And also, if you're going out this weekend, you should try to avoid Starbucks, Whole Foods, and Walmart. They are union busters. Thank you.
Thank you, Mr. Woodward. Questions or comments from the committee? Questions or comments? If not, appreciate being with us. Next up is Stuart Casper. Mr. Casper, you're on mute still.
There we go. Good morning, Representative Stastrom and Senator Winfield and members of the committee. Thank you for giving me the opportunity to speak to you concerning Raise Bill number 5237, an act adopting the Connecticut Interstate Depositions and Discovery Act. Connecticut is late in joining the party. Nearly, I think it's 45, soon to be 46 jurisdictions in the country have adopted this uniform act, along with the District of Columbia and the U.S. Virgin Islands. Connecticut has been working with the anachronistic system of using court-approved commissions for depositions, time-consuming, needless hurdle that needs to be overcome in order for Connecticut litigators of all sides, both sides, plaintiff and defense, commercial as well as injury, to seek discovery out of state. The Uniform Act adoption will greatly facilitate the process to the extent that there are incoming and reciprocal petitions or submissions of subpoenas requested from out of state. There's a $100 filing fee, so it should have a negative fiscal impact. And I believe universally, uniformly across all bar organizations and the judicial department, there is agreement that this would be a beneficial change to the judicial system and the process of discovery. Happy to answer any questions. I'm here representing the interests of the Connecticut Trial Lawyers Association.
Thank you. Senator Kissel.
Thank you very much, Mr. Chair. Just a quick question. You said that it's 46, about 46 other states. Would that include New York and the other New England states that have it? In other words, do our surrounding states all already have it?
New York has it. I believe Rhode Island has it. I don't think Massachusetts has it.
Okay, thank you. Thank you, Mr. Chair.
Further questions or comments from the committee? Representative O'Day.
Thank you, Mr. Chair, and thank you, Attorney Casper. I appreciate your testimony here. I have talked to people on this and agree it does make some sense. So I appreciate you coming out and testifying and educating us on the issue. Thanks.
It hardly seems like I'm coming out.
True. In the Zoom world. Thank you.
That's as good as we can do, though, right now.
Right.
Further questions or comments?
It does beat a drive to Hartford, though.
Well, it does, and sitting around waiting since 8 o'clock this morning in the legislative office building. So
Right.
there is that. All right. If there are no further questions or comments either about the bill or the legislative process, I think we can move on. So next up will be Commissioner Giffords.
Good morning, Representative Staffstrom, Senator Winfield, members of the Judiciary Committee. I'm Deidre Gifford. Thank you very much for the opportunity to speak with you this morning. I'm also joined by our agency legal director, Matt Antonetti, who can help respond to any questions that you have. I'm here to offer the agency's testimony in opposition to Senate Bill 164, an act concerning state agency compliance with probate court orders. We oppose this bill on a number of bases, including the law, fairness and equity, the potential cost, and the administrative burden to the agency and the state. Very quickly, Representative, if I could just remind the members of this committee, since DSS is not often before Judiciary, that the Medicaid program, unlike Medicare, which is a fully federally funded program, the Medicaid program, Husky, is a state and federal partnership. And that partnership provides our state with upwards of $4 billion per year to offset about 56% of the costs of the Husky program. Part and parcel of that federal funding are, of course, a number of requirements on the state to comply with certain regulations of the program. One of those is that there must be a single state agency that determines eligibility for the program, that's ultimately responsible for determining eligibility for the program. And such responsibility cannot be deferred to any other state agency. So that is one of the main concerns we have with this bill, that Section 1, which provides that each state agency that is a party to a probate court proceeding shall recognize, apply, and enforce any order, denial, or decree of the probate court that's applicable to any determination made by the state agency in a contested case. We're also, with respect to fairness, we are also very concerned that this legislation would really make an uneven playing field with respect to determination for eligibility for Medicaid benefits. Individuals with access to attorneys in the probate court, which may be uneven depending on the resources of the family and individual involved, could potentially make an end run around DSS's eligibility process by going to probate court, potentially even well before the application process, to obtain a decree which would make it more favorable in their eligibility determination. With respect to the law, binding DSS to the probate court decrees.
Commissioner, you're at the 3-minute mark. Just
Thank you. I'll just summarize by saying that with respect to the law, we are concerned, as I mentioned, that this would put us in conflict with both federal and state statute. And with respect to cost, could jeopardize both our federal funding and would require us to hire many more attorneys in our legal office to both attend and participate in the probate court proceedings. Happy to answer any questions. Thank you very much.
Sure. Representative Doucette, followed by Senator Kissel.
Thank you, Mr. Chair. Thank you, Commissioner, for your testimony. Just a quick question. I know we looked at this legislation last year, but just kind of trying to refresh my memory. Can you give me a specific example of the type of order that you're concerned with that could come from a probate court and the circumstances under which that order would be issued and how it would specifically conflict?
Yes, and with your permission, Representative, I'm going to defer that to Attorney Antonetti, if I could, who can give you a much more robust answer. Matt?
Good morning, members of the judiciary and Representative Doucette. So I'm Matthew Antonetti.
Sir, before you answer, I need you to identify yourself for the record.
Yes. I'm Matthew Antonetti. I'm Agency Legal Director for the Department of Social Services. Good morning. So an example of the types of issues that might present to probate that would ultimately implicate a DSS eligibility determination could be that a trustee present a request before probate to interpret a provision in a trust that might result in a determination that the beneficiary could not have, let's say, full access to accounts. That would then have an impact on DSS. So that would be an order of the probate court interpreting provisions of a trust. If that individual, the beneficiary, then were to apply to seek Medicaid, we would have a probate court order saying that those assets are not available to the beneficiary. Accordingly, DSS, that would implicate eligibility for Medicaid. Another example might be in a conserved situation where the conserved may not have a community spouse, but they might have a family member who is acting as conservator, might look to the probate court to approve a transfer of the individual's property with a recognition that there was a transfer, let's say, to another family member at a fair market value. That would be unopposed and likely would be, approved by probate. Sometime later, that individual looks to DSS for eligibility in Medicaid. We would then be bound by a probate court order recognizing that fair market value was received for a certain property, where DSS eligibility might take a look and might assess a different determination potentially. There might be also an example where an individual, again in a conserved circumstance, seeks a recognition from probate for, there's another provision where you could transfer a property for less than what might be considered fair market value if the individual is receiving long-term care services by a family member or someone residing in the home for a period of 2 years. So they might transfer a property to another family member, let's say for nominal consideration, but there's a recognition that they were receiving care in the home by the individual for a period of 2 years, which would also implicate Medicaid, the asset transfer. DSS eligibility might, subsequent to that order, understand that actually the individual providing the care wasn't living for a period of 2 years. But again, we'd be bound by that probate court order, could not do otherwise. So those are just a few examples of where a probate determination at some point prior to seeking or Medicaid eligibility obtains a probate court order that ultimately would be favorable, that would implicate and truthfully bind DSS to those determinations.
Okay, that's helpful. Thank you. Just one follow-up then. So how currently would those sort of conflicts be resolved? So you would say deny benefits in that situation, in any of those examples, that you cited. Is there any resolution process or appeal process that would work itself out, and how do those typically play out?
Yes, that's an excellent question. Were there to be any dispute with respect to an eligibility determination made regarding coverage, the individual, if there was an adverse determination, would have a right to a fair hearing before a DSS hearing officer to review the circumstance. And ultimately, that's the contested case that is under the Uniform Administrative Procedures Act. So ultimately, that could be challenged in Superior Court if there was an arbitrary or unfair determination. So yes, there is an appeal right through a fair hearing process and through the UAPA. And
okay, and then
yes.
Just one last question, I guess. Are there examples where when they're appealed in that manner that a court has held essentially to against DSS or to provide basically force you to provide benefits in that?
So that's actually also an excellent question. I've been agency legal director for the last 2 some odd years. I'm unaware. I have not seen any appeal come through to that effect. I do believe that there may have been a case interpreting some trust agreements several years back, 2015, 2016. But this is not something that I am aware of in any frequency, certainly in any active case that we have going in Superior Court, where there is this type of challenge.
Okay. All right. Thank you. Thank you, Mr. Chair.
Senator Kissel.
Thank you very much, Mr. Chair. Good morning. I don't know if this goes to the council or the commissioner. And by the way, Commissioner, it's great to see you before the Judiciary Committee. I believe I have one question. Does the Department of Social Services have to comply with orders of the Superior Court, of a Superior Court judge?
So we are not bound to the same effect of a Superior Court determination.
I mean, so you're saying you do have to comply with the orders of a Superior Court judge?
So the manner by which it would proceed through Superior Court would be on a UAPA appeal. So certainly if a Superior Court, we could appeal the Superior Court determination to the appellate court should we so decide. But that would be in the context of a particular case reflecting the appeal rights that Representative Doucette inquired about.
So what I'm saying is, does the Department of Social Services have to comply with the determinations made by a Superior Court judge? Yes or no, Counsel?
So in the aspect of should there be an appeal? Yes, an appeal of a determination.
Thank you, Counsel. Thank you, Mr. Chair.
Senator, if I could, and maybe Matt could amplify this a little bit. That appeals process that Attorney Antonetti was describing would be part of our Medicaid state plan. And Matt, please correct me if I'm making a mistake, but as I started my testimony, sir, we are bound by the terms of our Medicaid state plan. That is, in effect, the agreement we have with our federal partners to operate the Medicaid program, and upon which our state match is dependent. And I believe that appeals process that Matt described would be articulated as part of our state plan and eligibility determination, and which distinguishes it from the type of probate determinations, if I understand correctly. Did I get that right, Matt?
Yes, that's correct, and it's also spelled out in state statute. Correct.
Well, my concern is here we are with a proposal that would change state statute. And we've tried, myself, Senator Winfield, Senator Kelly, thought that we had tried rigorously to reach out to the department last year. Legislation did pass both chambers, ultimately being vetoed by the governor. In that scenario, what I've seen is the federal government sort of cast up as the bogeyman, and that, oh my, we'll be in violation of our agreement with the federal government, or oh my, we'll possibly lose millions of dollars if we go awry from what we have agreed with the federal government. And yet I haven't seen anything thus far from the federal government saying, if you do this, it will jeopardize XYZ. And so I think until we get to the nub of that, the fact that you have an agreement spelled out, which actually acknowledges that you must comply with Superior Court orders, albeit in a situation that's already been framed out, I want to see if we can get from point A to point B and not just keep trying to kill this proposal. So that's where I stand on this. I'm always looking for solutions, and that's it. I'll get off my soapbox. Thank you very much, Mr. Chair.
Senator, if I could offer, some of you might know that I was an official at the federal agency that oversees the Medicaid program before coming to Connecticut. And we did often receive requests from states. If such bill were to pass, what would the agency's position be? The federal agency typically declines to offer opinions on hypothetical situations, and usually would only opine on an existing question before them. So I'm not surprised that the federal agency hasn't weighed in, because that's typically not their practice.
I very much appreciate that, Commissioner. I guess what that says is we have to pass the bill to see what their reaction's going to be. Thank you, Mr. Chair.
Yeah, just on that point, Commissioner, I guess what I struggle with is, and the argument seems to be, we're the executive branch. We're going to do what we want to do based on the guidance we've received from the feds. It just seems like such a separation of powers issue to me that you would sit and say, we're not going to comply with a judicial directive. I don't understand how that holds up under a separation of powers analysis.
Well, my understanding, and I'll ask Matt to jump in, is in the narrow circumstance where the judicial action would be a de facto determination of Medicaid eligibility, that's where we get into the challenge. So a federal law that I referenced about the need for a single state Medicaid agency to be solely responsible for Medicaid eligibility determinations, that's the nut of the issue, Representative, as I understand it. Matt, please amplify if I got that wrong.
Yeah, there is a bit of a distinction here, and an important one, between the types of matters that would be before probate, likely before there is a Medicaid application or potentially a Medicaid application put in place, and those that might come up on an appeal of an agency determination, where an individual is appealing the agency determination. It goes through the Superior Court. The department may choose not to appeal if they disagree with the Superior Court determination. These are two distinct pathways, and I think, as I was trying to address with Representative Doucette's questions, the pathways by which individuals, and often those who may have more resources and may be more astute and have legal counsel with respect to estate planning or long-term care planning, in coming into the probate court system to effectively get those preemptive orders that would be taken into account as part of an eligibility determination by DSS. There, again, I'm not aware of cases where DSS eligibility has completely disregarded information that might go into the factors of whether an asset is appropriately eligible or not in accordance with Medicaid law regs.
But isn't your remedy in that case really, instead of fighting the statute, your remedy really is to go into the probate court proceeding and say, you know, this is premature, that the applicant, or it's really not even an applicant at that point, but the party involved in the probate proceeding has not exhausted its administrative obligations, and therefore, you know, dear probate judge, you shouldn't act on this.
So yes, I'm sorry.
No, I mean it seems like rather than say we're not going to comply after the fact, the onus should be to argue the probate case is sort of premature and should be barred that way.
So this is what would implicate my office more directly. And I think the Department of Developmental Services will touch upon this in their testimony, as well as far as state resources. Going down that path would require the Department of Social Services or the Office of the Attorney General to be present in, potentially hundreds. I think that, were the legislation to pass, this certainly would be something that would be advantageous in a lot of long-term care and estate planning circumstances. That would then require the Department of Social Services or Office of the Attorney General to appear in hundreds of what otherwise would not be cases where agency staff would so appear. And so, yes, we would, the fiscal implications aside from the federal reimbursement would be significant to the state and additional staff, because the state would be in a position to do exactly as you indicate. We would have to appear in hundreds of probate matters because it might implicate DSS eligibility, Medicaid eligibility.
Yeah, I guess I'm going to move on. I actually sort of didn't mean to go this long, and I think I cut in front of a couple people, so I'm going to move on. But I guess I have very little sympathy for, oh, gee, we may need to appear at hearings so that we don't end up having an order that we don't want to comply with. I mean, it seems backwards to me. But anyway, Senator Winfield.
That mistake doesn't happen all the time. Good morning, Commissioner Gifford. I was involved in this discussion pretty deeply last year. I guess I just want to get a sense of you. There was an effort to see if there was the ability to come together. That's not always possible, despite the fact that we try, right? I just want to get a sense from you and the agency whether you think those kind of conversations will be fruitful, because if not, I'd be happy to keep moving forward and try to figure out what we can do and not even engage in those conversations. I mean that seriously. We have a short session. I don't know what we're going to do. I just want to know if there's the possibility, or if it's just the kind of thing where it's just not possible.
Senator, I don't think it's ever wise to say we should stop having conversations. So I certainly would be happy to continue them. I will say, and I think it's important for the members of the committee to know, we are not aware of any other state that has a statute such as this binding the single state agency to probate court decrees. I think that's telling. And I think I fully appreciate the concerns that I'm hearing. But I do think when there's no other state that's gone down this path, it does imply that it would be challenging, to find a middle path. But that, Senator, I certainly happy to continue having conversations and try to find a resolution.
Thank you for that, Commissioner. And I think it is challenging. That's why we're here again. And just, Good morning, Mr. Attorney Antonetti. You're signed up later. Are you still testifying, or are you going to?
No, it was in support of Commissioner Gifford. So.
Okay, I just wanted to know for the record keeping. Thank you, Chair Stasha.
Thank you, Senator.
Representative O'Day.
Thank you very much, Mr. Chair. Just to follow up, I got to tell you, Representative Stastrom's questions were right on point with where I was going. I mean, look, did you read? I don't know if anybody read Senator Kelly's testimony. Did anybody from the agency read that?
I have not seen the senator's testimony, no, sir.
Yeah. Attorney Antonetti?
Yes, I did take a look at it, yes.
All right. So would you agree that there are issues that come up that, I mean, you're not, did you understand Senator Kelly's point of view and at least acknowledge that there are some issues that need to be resolved somehow? Is that fair to say or no?
Well, I mean, I'll be, honest, because the eligibility determination process does provide for appeal rights and a fair hearing. Again, if there is a thought that the department is inappropriately applying eligibility determinations regarding asset transfers or available assets for Medicaid eligibility, there is a clear pathway through a fair hearing and UAPA appeal to address those. So, I think any applicant for Medicaid always has that fair hearing right for a negative what they interpret as a negative or an adverse determination for eligibility.
But do you see though that I mean, Senator Kelly's testimony is simply that, you've got probate court orders or decrees that are being ignored or disregarded, that I think you admitted that wouldn't happen in the Superior Court, correct?
Well, no, I mean, again, with the Superior Court, the way that an order might be implicated in Superior Court would be through an appeal, a Uniform Administrative Procedures Act appeal of what is viewed as an adverse determination by DSS. So DSS would be, the defendant in that specific appeal. Again, with respect to these probate court decrees, I can only go off of what I have seen or haven't seen in my time as a legal director or my knowledge as to actual cases of which DSS is a current defendant. And I'm not aware of current cases or within the past few years where there has been what is truly seen as an arbitrary or an ignoring of a probate court order or decree in determining long-term care services or Medicaid eligibility. My experience has been the individuals who make these determinations work very hard at trying to reach what is an appropriate result within the guideposts of the federal law and Medicaid requirements. But again, if they don't do that, there is an appeal right. I do not believe, honestly, that there's any disregard or, of what might be a probate determination. But eligibility within DSS, we are the single state agency that does have to make sure that determinations are in accordance with federal requirements.
Thank you. Through Mr. Chair, you haven't seen it during your time as legal director. How long have you been legal director?
So I have been legal director for 2 years. However, I am overseeing all currently active cases through DSS, and which are being represented by the Attorney General's office. And I'm not aware of any that, if there are particular circumstances that could be brought to my attention, I'm happy to review those and look at those.
I don't mean to be rude. So you've been at DSS for 2 years. Were you at DSS before that?
I was with the Department of Public Health for 20 years.
All right, so I'm just saying the time as legal director, you haven't seen an issue. That's only been 2 years. So to be fair, I just I do very much appreciate you coming in your testimony but I'm reading the testimony of Senator Kelly. I'm listening to what's been said here, and we're not looking for a solution to a problem that doesn't exist, right? That's not in what we're doing. So I appreciate your comments. I just think there's got to be something more we can do, and simply saying we'd have to hire more people if you pass this bill. As the good chair stated, I'm not. That's not going to sway me. In contrast to what I'm hearing from others, but I appreciate it very much, sir. I really do appreciate it. Thank you, Mr. Chair.
Further questions or comments from the committee? If not, I appreciate both being with us today.
You're welcome.
Next up will be Tom Girardi.
And Mr. Speaker, if you would just tell Mr. Girard and also Mr. McCarthy, I have been allowing them to be promoted as a panelist. They need to affirmatively click the box that says promote to be panelist, because if they don't, they're going to stay as an attendee. So if you would just let them know to do that.
I've done that. I can see everyone. Can everyone see me? I'm a panelist, I think.
Okay, good.
Mr. Chairman, you can see me all right?
I can. Yep, go ahead.
Okay, good. Thanks. My name is Tom Girard, and thanks for the chance to speak to you this morning. I am aligned with the Connecticut Conference of Municipalities on Senate Bill 204, and I am testifying in opposition to Senate Bill 204. And the first point of emphasis is there already is no governmental immunity for the average municipal employee driving around in a town vehicle. Our public works crews, the school buses and all the school vehicles, the trash collectors, the snow plows, the municipal town manager or the town engineers driving around. They already right now under longstanding existing case law have no governmental immunity if they get in an accident. You don't need to pass this bill in order to avoid that happening. I've seen some material submitted to you that say, well, we need to be the same as the state of Connecticut, and so we have to pass this bill. The state of Connecticut has a different immunity. It's a blanket sovereign immunity that would protect everyone who's a state employee from being sued. And they did have to pass a law to let people sue state employees when they get in motor vehicle accidents. You don't need that for town employees. That's the first point of emphasis. And so where that leaves you is the only group that would be affected if you pass this bill are the emergency vehicle operators, the ambulances, the fire trucks, the police officers. There's already a legislative scheme protecting that type of operation. It's General Statutes 14-283, and it strikes the balance, and this has been in place for many years, that you can have an ambulance go into an intersection if it has lights and sirens on, and if it is stopped or slowed down enough to make sure it's safe to do so. And they never lose their responsibility to drive with due regard for the safety of all others. That statutory scheme is already in existence, and we don't need to curtail that. That's my second point of emphasis. My third point of emphasis is if this is passed, there will be a negative effect on the services that we receive in our cities and towns. Most of the ambulance and fire departments are volunteers. And if they receive this message that the legislature has exposed them, taken away protection by passing this bill, there will be less volunteers. And in the towns, if you can't staff with volunteers, you don't have the service to be able to provide. They don't have the budgets to have full paid fire crews. In the big cities, people say, well, let's let insurance pay for it. The big cities have policy premiums that are so exorbitantly expensive for liability insurance that they self-insure for the first $500,000 or $1 million. So they don't have insurance that kicks in until that much has been paid. And if you pass the bill, the impetus will be on the cities to say, we can't go quickly. We can't strike the balance anymore because we can't afford the loss of money that would result in loss of services. And the people who suffer the most then are the people who need the services the most, the people in the cities who need the fire department to respond. They
So
need the ambulances.
You're at the 3-minute mark.
Those are my 3 minutes. I've prepared written remarks, and I would ask everyone to please take a look at them. They amplify what I'm saying, and I thank you very much for the chance to speak this morning.
Sure. I have a question for you from Representative O'Day.
Sure.
Good to see you, council. Thank you for your testimony. I'm taking a look, and I did have those conversations with some of the advocates of this with the CTLA. I assume you read their testimony. I have not had a chance to see your testimony, Tom. Is it, are you certain it was submitted, or are you just submitting it today or yesterday?
It was submitted last night, and I think CCM is submitting it. I've asked them to submit for me.
Okay, so I'll certainly take a look at that. If the paragraphs that are in question, or the lines of 204 that are in question, are 22 to 25. If we were able to add their exempting volunteers, would that be something that you'd be amenable to, or is there just too much of this that doesn't make sense?
No, exempting volunteers won't solve the problem that all emergency vehicle operators will be losing the protection that they currently have, and it will upset the scheme that's in place already by 14283. The fire, the police, the ambulance in all the cities that are paid, in Hartford, New Haven, Bridgeport, they would lose the protection they currently have, and that would really just inspire the cities. And like I say, they have self-insured first $1 million in Hartford, Bridgeport, New Haven, Waterbury, Stamford. Those are the people that need these services the most, and you'd be telling them you're losing your protection. Get there slower. Don't get there as quickly. And then you know what they respond to. They respond to heart attacks. They respond to burning buildings. They respond to serious motor vehicle accidents where every minute counts. And just to add to that, for 30 years, the law has been settled that the average Joe municipal employee who's not in an emergency, and that includes police cruisers who are just driving around on patrol, or an ambulance is just making a transport, not an emergency, or a fire engine coming back from a scene, they all do not have immunity right now. And that's well settled law. It's at least 30 years old. Well settled. So you don't need to pass this bill in order to be able to have people be sued for that and then raise an immunity defense. It's only the emergencies that would be impacted.
Yeah, I know you and I have litigated cases with and opposed to one another, so I know you're very familiar with it, and I appreciate your testimony. I look forward to reading it. Is there anything else you wanted to add that you didn't get a chance to address?
The only final point is often police pursuit gets raised when we talk about the ability to bring suits. And just remember that I want everyone to remember there's that has been addressed in General Statutes 14-283A. And that's been modified by this legislature in 2018, 2019. The ability to have a police pursuit happen has been greatly circumscribed, greatly curtailed. There's now a mandate for a statewide mandate for policies. And so you wouldn't want to say, I think we should pass this in order to make police pursuits safer. That's already a part of a complex scheme that this legislature has dealt with just in the past couple of years.
All right, thank you, Mr. Chair, and thank you, Attorney Gerard, for your testimony.
Thank you.
Thank you. Further questions or comments? If not, we will turn to Jordan Schiff.
I'm checking the time. Good morning, members of the legislature, Senators Winfield and Kissel, Representatives Staffstrom and Fishbein, and members of the Judiciary Committee. I'm Jordan Sheff, Commissioner of the Department of Developmental Services. Thank you for the opportunity today to testify in opposition to Senate Bill number 164, an act concerning state agency compliance with probate court orders. Our department's concern with SB 164 centers on provisions in Section 1 that would enable the probate courts to require any state agency to follow a probate court's order or decree applicable to state agencies, even though the probate courts are intended to be courts of limited jurisdiction. We are concerned that this new provision would extend the probate's court authority in a manner that could, one, provide a mechanism to circumvent the department's process of funding prioritization based on the needs of individuals. Two, necessitate numerous additional staffing resources. Three, conflict with federal and state laws, jeopardizing the department's ability to claim federal reimbursement on a variety of supports and services. Access to DDS programs, both state and federally funded, are not an entitlement. Funding to serve additional individuals is appropriated in each biennial budget. Because the appropriated funding is never sufficient to provide every person who meets the statutory definition of intellectual disability with services, the department must make critical decisions on who is in most need of the limited funding and what services and types of services are available to meet those needs. DDS already has a process in place to prioritize funding based on an individual's needs. This legislation could extend probate court's authority to create a mechanism to circumvent the department's process and place certain individuals ahead of others in the prioritization process, who may not necessarily have greater needs. Such an outcome would have the probate court usurp DDS's responsibility to determine eligibility and priority for funding and on whom state and federal Medicaid dollars are spent. I have submitted a very robust, full written testimony and was making an attempt to abbreviate that before you today. I just want, and I'm happy to take questions. It's important to note that in addition, requiring the department to appeal any such probate court orders to Superior Court would require additional resources within the department, as well as support from the Office of the Attorney General on particularly difficult or complex cases and subsequent appeals, which would be a significant expense both for the DDS and Office of the Attorney General. The legislation would strain existing staff resources and potentially require the department to hire additional staff, including case managers, direct care, and attorneys, depending on the court orders. For these reasons, the Department of Developmental Services must oppose Senate Bill 164. And if you will indulge me just one more second before I turn it back to you, I tried to get that in under 3 minutes. I see that my lead counsel, MJ McCarthy, has been promoted to panelist from attendee. She had registered so that she would be available, but I don't think she will provide separate testimony, just will be available for comment in the event you have questions for me. And I thank you for your time and allowing me to testify.
Thank you, Mr. Sheff. Are there any questions for the witness? Seeing none, thank you, Mr. Sheff. And I think, is it Mr. Mezek, the next witness?
Yes. Okay. I just wanted to let the proponents of the bill and the committee know that DDS is available if you'd like to discuss further changes in language that would be amenable to the department to allow this bill to move forward in a modified form. And we'd love the opportunity to discuss that. And I apologize for taking more than my 3 minutes. Thank you all very much.
Thank you. I think Mr. Mezek is the next witness.
Good morning.
Please start your testimony.
All right, thank you, Representative Blumenthal, Chairman Winfield and Staffstrom, ranking members Kissel, and I'm not sure if Representative Fishbein is here, and members of the Judiciary Committee. Good morning. My name is Brian Mezek. I'm here for the State Marshals. I am president of the State Marshal Association of Connecticut, and I'm here this morning to speak on SB 203. We really appreciate the committee taking up issues that concern our state marshals, and as you know, we play an important role in the civil court system. The bill before you this morning generally provides for changes to the fee structures for state marshals. There haven't been changes to those fees since 2014, and some other fees go back even farther, back to 2002. Because we conduct our work as independent contractors, we don't receive a salary or any state benefits, so our total income and operational costs are derived solely from the fees that are authorized by you, the legislature. Our costs have gone up significantly, and this bill is increasingly needed for the state marshal system. Throughout the pandemic, marshals were required to keep working, and I'm happy to say we show up to the courts serving serious orders like restraining orders and protective orders. And our positions require a lot of travel. However, there's times that we don't always get compensated for it. For example, when we serve a temporary restraining order, we're expected to make personal enhanced service, especially if the order indicates that the respondent possesses firearms. Currently, our statutes only allow a marshal to bill for travel on one successful trip when the service is actually made. So one important thing that this bill does is acknowledge that at certain times, marshals have that challenge of making in-hand personal service, and it's not always easy. And sometimes it takes more than one trip to do that. So the bill contemplates actual travel costs in very specific instances where we're requested or required by law to get the person in hand. And appropriately, the bill contains some guidelines on that mileage. And then another important thing that this bill does is concerning the safety of state marshals. And as you know, threats, attacks, and harassment and retaliation against public officials, it's an increasingly growing problem. Marshals are sworn officers. We have the status of peace officer, but what we lack, however, are the privacy protections that other peace officers are afforded. State marshals perform many enforcement actions for our civil courts, such as executions, evictions, ejectments, civil arrest, and transport of individuals held in contempt of court. So SB 203 would appropriately give the marshals the same protections that other peace officers are given, namely using a business address with the DMV and not letting the state disclose our home address out of our personnel files. And that's a big concern for us. We handle a lot of tough situations, but we need to be able to go home at the end of the day knowing that the state has also done its part to keep the marshals safe. So we would ask you to do that. I thank the committee very much for the opportunity to testify, and I'm happy to answer any questions that you might have.
Thank you, Mr. Mezek. And looks like Steve, the chairman's back.
Sorry, thank you, Vice Chairman Blumenthal, for filling in. I have to take a super quick call. Thank you, Mr. Mezek. Questions for comments from the committee? If not, I want to certainly thank you for bringing this to our attention. It has been a long time since the marshals have gotten a raise, and this is certainly a very, very modest one. I, for one, firmly believe that it is time that you get the raise.
We appreciate that, Mr. Chairman. Much appreciated. We thank you.
Further questions or comments? If not, thanks for being with us.
Thank you, sir.
Next up will be Lisa Stevenson. Lisa Stevenson.
Good morning.
Good morning.
I want to thank the Judiciary Committee for allowing me to address Raised Bill 203. I'll be speaking on the point of shielding the home addresses of state marshals. My name is Lisa Stevenson. I'm a Connecticut State Marshal from Harford County. I also sit as an ex officio member of the State Marshal Commission and a member of the advisory board. I've been a deputy sheriff and a state marshal for over 26 years. In accordance with the Connecticut General Statute 6-38, Connecticut State Marshals provide legal execution of service of process. Our responsibilities include housing and superior court evictions and ejectments, as well as capiases, divorces, child custody, and restraining orders to name a few of the other services we provide. The challenge we face while fulfilling our duties has changed substantially in the past few years. The level of verbal abuse and threats while serving papers has significantly increased. We are requesting the additional level of protection by limiting access to our home addresses by being added to the Connecticut General Statute 1-217. Under the statute, police officers, firefighters, judicial departments, DCF, the Department of Corrections are all covered, and we would like the same protection. This protection would make it difficult for individuals to determine our home addresses. We feel unsafe with this information being readily available. During the course of my career, I have personally seen an increase in sovereign citizens' activities while performing my duties as a state marshal. I, along with my colleagues, feel more in danger than we've ever been. Sovereign citizens are extremists who oppose taxation, have no respect for authority, whether you be police, judges, probate judges, clerks of the court, town employees, or state marshals. These sovereign citizens are commonly referred to as paper terrorists within our court system. These individuals do not believe in recognizing common law or authority figures. We are frequently threatened by their violence and their work to protect their beliefs. The Judiciary Nominating Committee was exposed to one of them in a public hearing last Friday when this individual continued to yell after her 3-minute allotment. Senator Stafstrom found out firsthand the temperament of what we're up against. This person has harassed and threatened me and my staff We feel unsafe. We've resorted to locking our business doors. We no longer allow the public to enter. I felt this was a necessary measure to protect my staff. In the past, state marshals tolerated occasional and mild verbal bullying and abuse as part of our job. Unfortunately, these episodes with these types of individuals is increasing. The violence and extremist ways are now requiring us to engage with local municipalities and the state police to clear homes before we do evictions and ejectments. This was never part of the past. These individuals are also placing liens on residential properties they do not own. They've even placed liens on state marshals' homes, and that could be interpreted as a form of retribution. These liens create encumbrances on our properties. In addition, they fill our post office boxes with papers that make no sense. They fill our voicemails with threats. They file complaints with the State Marshal Commission without merit. All of it's taxing. It's taxing on the judicial system, our law enforcement, and creating undue and stress and danger to all of us.
Ms. Stevenson, we're at the 3-minute mark. I'm sorry.
I just respectfully ask the committee to add us to the bill, Senate Bill 1-217.
Great. Thank you very much. Questions or comments from the committee? Questions or comments? Seeing none, appreciate you being with us. Next up is David Widlick.
Yeah, Dave Wylick.
Widlick, all right. Sorry about that.
And I make this easy. Good morning, senators and representatives and all of the members. And I thank you for all the work you all do. Like you said, my name is Dave Wylick Jr. I'm president of Communication Workers, Local 1298. We represent mostly Frontier and AT&T workers and telecommunications. I'll be very brief. Currently, I had a call from somebody who's in our industry that was looking to join a union. And I have to be very, very careful with approaching that opportunity with those employees. Because what will happen is, as soon as word gets out that this guy was calling me to talk about organizing a union, everybody will be dragged into a meeting and told how bad unions are. And I just think that this is one piece of legislation that I strongly support that helps eliminate that particular roadblock. I think that, just having a workbook or a handbook between an employee and the employer that's collectively bargained and is fair to both parties is not an unreasonable ask in our world today. And it helps promote good middle-class jobs. There aren't unilateral changes and people aren't let go without just cause. So again, I just am here today to really strongly support this piece of legislation. And I thank you very much.
Thank you, sir. I got a question from Representative Porter.
Thank you, Mr. Chair. No question. Just wanted to say good to see you this morning, Mr. Wylick, and thank you for your testimony this morning in support of this very important bill. Thank you, Mr. Chair.
Good to see you too.
Thank you.
Further questions? If not, thanks for being with us this morning. Next up is John Butkus.
Yes, good morning, Mr. Chair, members of the committee. Thank you for the opportunity to speak today. I'm here to speak in favor of House Bill 5236, which we as the proponents of the bill colloquially call the Good Samaritan language for architects. Written testimony has been provided to you through AIA Connecticut, the local chapter of the American Institute of Architects. Within AIA Connecticut, I'm the co-chair of the Legislative Affairs Committee. I'm also what's known as the Disaster Assistance Coordinator for Connecticut through AIA Connecticut. AIA as a national organization has long supported having groups of volunteers to assist emergency services, local departments and building departments, et cetera, in the evaluation of structures after an emergency, in the interest of providing some evaluation that would determine whether a facility can be reoccupied after a disaster, whether it be a flood, hurricane, tornado. The goal here being that anyone who can return home safely is one less refugee that needs to be supported by emergency services. There is existing language in CGS 20-308A that protects engineers who volunteer their services in an emergency. There has historically not been a parallel protection for architects who voluntarily contributing their time and expertise to assist emergency services folks. And right now we have been unable, and myself as the disaster assistance coordinator for AIA Connecticut, to be able to field volunteers or to frankly recruit them with any confidence that by providing their time voluntarily that they won't be held to an unreasonable standard of liability. So the language in HB 5236 provides that level of protection. Again, these are pro bono services. In fact, it's not even technically services. We're not providing design. We're volunteering as safety evaluators. And our goal here is to provide, as I mentioned, the parallel level of protection that engineers already have in order to make ourselves available as supplemental services to the emergency services community. And I thank you for the opportunity to speak and be happy to answer any questions.
Thank you, sir. Questions or comments from the committee? Questions or comments? Seeing none, appreciate being with us this morning.
Thank you.
Okay, Eric Chester, Bonnie Stewart.
I'm here. Eric Chester's here. I apologize.
Oh, okay. Go ahead, Mr. Chester.
Good morning, Senator Winfield, Representative Stravstrom, Senator Kissel, Representative Fishbein, and the distinguished members of the Judiciary Committee. My name is Eric Chester. I'm an attorney with Ferguson, Doyle, and Chester. Our firm represents a number of unions throughout the state of Connecticut. I'm here to testify in support of Senate Bill 163, an act protecting employee freedom of speech and conscience. Let me say at the outset, previous witness testified in support of this bill, a union activist, is when a union or when a group of employees is considering joining a union, often what will happen to initiate that process is that a union organizer will look to meet the worker more often than not at their home. And they'll have a discussion at the kitchen table about the benefits of joining their fellow coworkers, forming a union, and bargaining collectively with their employer to reach a contract. And oftentimes the employee will sign a card expressing their interest to move forward and have an election. And that's kind of how the organizing effort works from the union side. You get a majority of workers that agrees with moving forward, you have an election, and if the union prevails, you have a union. What the employer often does, regrettably, is they will engage in what's called a captive audience meeting, where they call the employees into a meeting, and it is a closed door meeting. And whether it's the employer or whether it's a hired consultant from the outside, will come in and look to, persuade the employees not to participate in the organizing of a union. These can be coercive, they can be intimidating, and the employees are stuck there, forced to listen. What SB 163 does, it allows an employee, gives an employee the right to disengage from that meeting, to leave, and not have to listen to the threats, the intimidation, the coercive tactics of an anti-union employer or their hired consultants. That's it. It does not restrict the employer's ability to meet with their employees for issues related to their employment or anything else. All it does is it allows the employee to say, I'd rather not be here, and that employee can leave. And what SB 163 further does is it insulates that employee from unwarranted discipline, unwarranted threats of discipline for leaving that meeting. In the event the employee says, I've heard enough, I'd like to leave, I don't agree with this, they leave the meeting, and they are disciplined. They're threatened, they're terminated. What SB 163 does is it affords additional remedies for that employee to seek through litigation. And some of those are in the bill. It's punitive damages, reimbursement of attorney's fees, and those types of things. Those remedies presently don't exist. What we have now is just insufficient. The remedies that exist now under the National Labor Relations Act are simply reinstatement of the employee if they were disciplined as a result of leaving the meeting, perhaps.
Thank you, Mr. Chester.
And yes, I'm sorry.
We're past the 3-minute mark.
I apologize. And then the other, really the only other remedy afforded under the NLRB or the National Labor Relations Act is perhaps a new election. So what SB 163 does, all it does is it allows an employee to leave a closed door captive audience meeting and not be threatened with undue, unwarranted termination or discipline.
Thank you, Mr. Chester.
Thank you.
Questions or comments for Attorney Chester? Questions or comments? If not, we appreciate you being with us this morning.
Thank you for having me.
Bonnie Stewart is next.
Good morning. It's morning still. My name is Bonnie Stewart, and I'm the CEO of the Connecticut Society of CPAs. And I thank you for the opportunity to appear before you to comment on House Bill 5235. CTCPA strongly opposes this measure. We believe that it discourages offers of compromise, it's unfair to defendants, and it actually will drive up everyone's costs. As drafted, this measure would change the interest accrual start date, and by moving it up to the date of injury, we believe that plaintiffs will be less motivated to make reasonable offers or to settle in a timely manner. In addition to that, you can have some individuals, defendants in this case, that would not be aware of an injury. So that's particularly problematic because the interest starts running before someone's even aware that there's an injury that an offer should be made on. Between the offers of compromise being less likely to happen in a timely manner, the probable increase in investigatory costs if a claim is filed later, the later it is, usually the more expensive investigations are, the more difficult they are, and the increased interest, you're going to see our overall costs in terms of litigation and insurance increase for businesses and individuals alike. And therefore, we respectfully request that you reject House Bill 5235.
Thank you.
Thank you.
Questions or comments from the committee? Seeing none, appreciate being with us.
Thank you.
Christopher Hutchinson. Let's see, Christopher Hutchinson. There you are, Mr. Hutchinson. I think if you try and mute yourself. There we go. Yep.
Thank you. Sorry about that. I was trying to get off.
Your camera's off.
I'm not seeing the part where I can turn it on. Oh, okay, here we are. I got it. Okay, now I'm on. All right.
There we go. All right.
Thanks. Sorry for the delay. All right. Thank you, everyone. So 3 years ago, I gave testimony about the stress and anxiety inducing experiences with captive audience meetings. And I think it's incredibly frustrating and even sad to think that for the last 3 years, any worker trying to form a union in Connecticut has been subjected to the cruel treatment we experienced in Stanford. I was a Stanford hotel worker at the Sheraton Hotel. So I'm here to speak in favor of SB 163. Captive audience meetings are a form of psychological terror, and that makes a wound by slowly taking away your dignity over a period of weeks. Each day, the anti-union, union busters, they poke at the wound until you start to have doubts and eventually, vote against making a better future for yourself by rejecting the union. And when we formed our union in 2019 at the Sheraton, we prepared months in advance to withstand the pressures of captive audience meetings. We saw what happened to other workers in the same situation. The NLRB allowed the company for 4 grueling weeks to assault us daily with half-truths, slanders, and outright lies. Anti-union firms like Lupe Cruz and Associates sent 4 union-busting consultants to intimidate and target our coworkers and management with captive audience meetings. They lived in the hotel the entire time. The union-busting consultants had 24 access to us and would hold workers in captive audience meetings for 2 to 3 hours at a time. The meetings would start at 9 a.m. and they would run as late as 3 a.m. And when they were not holding meetings, they would wander around the hotel and hold private conversations, trying to build personal relationships, sometimes even flirting with workers. Each captive meeting, they would try to trick us. They told us that the union was a business, an outsider, and only wanted our dues, as if we hadn't done the organizing ourselves. They would cherry pick pieces of labor law and put it out of context so that it looked like unions would harm us. They especially targeted our religious coworkers. They literally made people believe that the union, the local number 217, our buttons and colors were all associated with Satan. The captive audience meetings extended to our coworkers' personal lives as they targeted individuals and visited them at their homes and even went to church with them. The union-busting consultants held one of my diabetic coworkers, Arturo, in meetings until his blood sugar level dropped so low that he thought he was going to pass out. The anti-union consultants spread vicious rumors during the captive audience meetings about myself and other coworkers. They lied to my friends and told them that we were paid by the union and that we shouldn't be trusted. All they did was sow division. Many who had initially supported the union were tricked into voting against their best interests just to end the torment. But the majority of us held out against the captive audience meetings. We were lucky to have a union that prepared us to go through such a dehumanizing experience. All we wanted by forming a union was a voice to speak against the awful wages and working conditions that existed in our hotel and in all non-union Connecticut hotels. It's hard to imagine that such a practice is legal. We need to end this psychological terror waged by the bosses against working people now. And I thank you for the time and chance to speak before you today.
Thank you, sir. Looks like we have a question from Representative Blumenthal.
Thank you, Mr. Chairman, and thank you, Mr. Hutchinson, for your testimony today, as well as your work in organizing. One of the most disturbing stories I heard about these captive audience meetings here in Stamford, actually at a hotel that was being organized by your union, was that individual, mostly female room cleaners were being, or house cleaners were being essentially approached while they were on the job in hotel rooms with multiple people from these union avoidance firms, essentially cornering them and making threats about what would happen to their jobs. Sometimes this was, after it was in, nighttime hours or other hours. So I heard stories like this and I was wondering, first of all, is this something that you've observed as well? And also, what are some of the dynamics at play that kind of upset a normal power balance between people having a conversation in some of these captive audience meetings?
Sure. Great question, and thank you for your support too throughout our fight in the hotels. I personally didn't see it happen, but I heard many stories from coworkers. People would come up to me. I worked the front desk. People would come up to me at the front desk, stressed, panicked, like, what do I do? What do I say to these people? And, basically just have to tell them you don't have to talk to them. But the fact that they had 24-hour access, in our case, we're probably one of the most severe cases of captive audience meetings where they can live right where we're working and just wander around the hotel and at any moment pop into a room, even close the door and start questioning someone or start, and some, they brought in people specifically who also spoke the language, either Spanish or Haitian Creole, and targeted those individuals who they thought, would fold the quickest. And this was like part of that power dynamic that, right, because they had 24-hour access to us, they could just start up these conversations every time. And like I said, they would try to build these like real personal relationships. So they would have the meetings where they would like tell all the technical stuff. And then afterwards they'd be wandering around and just, oh, how you doing? How's your family? Make it like they were friends, and then slip in the discussion about, anti-union stuff. So the captive audience meetings never ended. It was like you'd get out of one and then you'd get into another one. And it was really confusing as to where the line was drawn in this. Like, was this an informational meeting? And it's not, so it was a real nightmare situation. I've never experienced anything like that in my life. And, I hope no one else has to experience anything like that.
Thank you, Mr. Hutchinson. Yeah, some of these stories were especially disturbing to me because a lot of these folks are relatively new immigrants. They don't know our laws, or they don't know necessarily how things work, and as well as other people, who speak English as a first language may, or have been here longer. And the potential for intimidation seems to me very high in some of these circumstances. So that was, to me, something that was very disturbing, hearing about some of these stories. And thank you for your answers. Thank you, Mr. Chair.
Further questions or comments from the committee? Seeing none, thanks for being with us.
Thank you.
Jody Barr. Jody Barr with us? All right, let's try Jessica Petronella.
Hi, good afternoon, Representative Staffstrom and distinguished members of the Judiciary Committee. My name is Jessica Petronella, and I am the organizing director for UFCW Local 371 in Westport, Connecticut. And I'm here to testify in support of SB 163, an act of protecting employee freedom of speech and conscience. I've helped workers join our union for over 9 years. It's workers' federal right to form a union at their workplace, and this process should be fair and equitable. However, instead, the process to form a union often includes employers hiring union-busting consulting firms at a costly price. These union busters divide workers against each other by creating fear, confusion, threats, lies, and intimidation, either before or after the workers petition for their union election. Union busters manipulate workers at the expense of workers trying to improve their wages, benefits, and have a voice in their workplace. The main tactic used to intimidate workers during the election process is to hold mandatory captive audience meetings. These union-busting firms are presented to workers as educational consultants that are hired to make sure workers get all the facts before they vote in their union election. In these meetings, workers are forced to stop working during their work shift to listen to mandatory hours-long meetings almost every day until the workers vote. When the workers at Dollar General in Barkhamsted, Connecticut were attempting to join our union, Dollar General hired union busters and threatened to close the store if workers unionized. Dollar General paid union-busting consulting firm around $378,000 for a 28-day campaign to pressure the workers against organizing. On March 16th, the workers at Glambia Nutritionals in West Haven, Connecticut and Orange, Connecticut will be voting to join our union. Glambia hired union busters who told the workers in captive audience meetings that if they join our union, they could lose all the benefits they currently receive, be fined if their coworkers go on strike and they cross a picket line, will pay assessments, fines, and fees, and they'll no longer be able to go to their boss directly with an issue. This misinformation scares and creates the impression that workers are not part of the process during or after they vote for the union. Glambia has paid this consulting firm upwards of $450,000 by the time the workers vote. Forced captive audience meetings gives union busters the ability to surveil workers who are then able to identify workers who are in favor of the union and those who are against. The union busters are able to get workers to turn against each other by creating a hostile work environment. Identifying the workers who are supporting the union in captive audience meetings gives the employer the ability to retaliate or fire workers who are in favor of the union. These meetings taint the secret ballot
Ma'am,
election.
we're past the 3-minute mark, so I just need you
Sure.
to summarize.
Thank you for holding this very important public hearing today to allow workers to share their experiences in captive audience meetings. And I urge the committee to protect workers' constitutional rights by passing SB 163. Thank you.
Thank you. Questions or comments from the committee? If not, I appreciate being with us this morning. Next up will be Roger Weldon.
Let's see how Roger does. There he is.
Roger, you're on mute in front.
How's that?
Yep, good to go.
All right. Thank you, members of the Judiciary Committee, for hearing me. I've already submitted a statement, which is already on the record, and the testimony of Jessica Petronella is accurate when it's concerning what's been going on at Glanbia Nutritionals. I do speak in favor of SB 163, an act protecting employee freedom of speech and conscience. As we all know, freedom of speech is enshrined in the Constitution. It guarantees everyone the right to speak their beliefs through their own conscience. When we have the captive audience meetings, that effectively ends the employee's ability to have their freedom of speech. And establishing this bill into law will level the playing field so that the employees will then again have their freedom of speech. They'll be able to speak their own mind and their own conscience, and they'll have the ability to decide, I don't want to listen to this. I know what I want. And they can leave without any repercussion for their acts. President Biden, in his speech on Tuesday of the State of the Union, said distinctly, when a majority of workers want to form a union, they shouldn't be stopped. Passing this bill will allow the state of Connecticut to make good on that statement by President Biden. I thank you, Steve, and all of the members of the Judiciary Committee for considering the passage of this bill, and I heartily urge each of you to vote in favor of it.
Thank you, Roger.
Thank you.
Good seeing you, and
You as well, Steve.
see you around the neighborhood this weekend.
Yeah, I'll see you.
Questions or comments for Black Rocker Roger Weldon? Seeing none, we will move on. Maribel Rodriguez.
Good afternoon, Senator Winfield, Representative Strassman, and members of the committee. My name is Maribel Rodriguez. I'm an 1199 member. I currently work as an organizer for District 1199. I was a CNA in a nursing home for 30 years. I'm here to testify in support of Senate Bill 163, and I want to share my own story about management intimidation. A couple years ago, the nursing home I was working at was sold, and a new company came in to run it. The regional manager asked to speak with me at one point. I was taken aback by the request. I didn't know what he would want to speak to me about, and there was no reason for him to make this request. I remember asking him, will this take long? Because I was busy doing my job. He said no, and then he took me to his office and proceeded to keep me there for about 3 hours. The whole time asking me questions that were clearly meant to get me to sell my coworkers out. To sell my coworkers out. He was trying to create division between us. It was so upsetting to me. I pride myself in being honest, and I would never betray my coworkers' trust in me or my union. And I thought, how dare he think I would betray my morals and beliefs? We went back and forth for hours. I thought our conversation would never end. After 3 hours, I made it clear that I had integrity and would never sell out my coworkers. He was not too happy with me, and I was shocked because I had not experienced that since we first organized to join the union about 20 years ago. Senate Bill 163 gives the employees the right, when the subject of the meeting is about the employer's position on politics, religion, or labor organizing, to stop listening, walk away, and return to work, and not participate without the fear of discipline or termination. Employers should be accountable for the intimidation and fear they create when they engage in union busting. Please pass Senate Bill 163 to protect workers' rights in Connecticut. Thank you for your time.
Thank you, ma'am. Representative Porter.
Thank you, Representative Stasham, Mr. Chair. Thank you, Ms. Rodriguez, for your testimony. I just wanted to say that I'm really sorry that you had to experience that. And thank you for lending voice to why this bill is so critical and why it is needed more so than ever. 20 years is a long time not to deal with that. So I can imagine the shock of sitting 3 hours under that kind of intimidation. So thank you for having the courage to be here today. And thank you for your support. Thank you, Mr. Chair.
Thank you, Representative Porter.
Further questions or comments from the committee? If not, thanks for being with us, Ms. Rodriguez.
Thank you.
Jennifer Brown. Jennifer Brown.
I'm here. Good morning.
Good morning. Ms. Brown, your camera's off.
Yeah, I want to keep it off because I'm reading.
Okay. All right.
Okay. So I'm going to turn it on real fast. Good morning, everyone. So, good morning, Senator Whitefall, Representative Stratford, and members of the committee. My name is Jennifer Brown, and I've been a group home worker for 25 years. And I'm a delegate and an executive board member at 1199. And I work for 3 union companies. Yes, I work for 3 companies. Today, I'm here to support Senate Bill 163 and talk about one of those companies, Sunrise Northeast. If you remember last fall, Sunrise Northeast members decided we were going out on strike because management was not passing on the funding that we fought for and you all helped us receive. We were out for almost 3 months trying to make sure that management did the right thing. And instead, they spent thousands of dollars on union busting company in Jackson Lewis to try to intimidate us and manipulate the workers. We experienced a very stressful fight. We were constantly lied to, intimidated, and belittled. They tried to divide us as workers by singling out leaders and delegates and pitting staff against others, claiming that we were holding up getting a contract. Meanwhile, they were the ones actually holding up the process. We received harassing texts, calls under the direction of Jackson Lewis. The communications contained outright lies about where we stood with negative negotiations and how much movement management had made. They just lied all the time. Other communications tried to guilt trip us about client care. The worst lie we experienced was that when they sent an email and a text message that linked to a video, the video was of a woman stating that she had worked with us for over a decade, which was a straight out lie. The woman lied about how much money management had already put down. She also painted us and our union in a bad way, blaming the strike on us. Oh, Jesus. Sorry. Somebody start calling me. Blaming the strike on us rather than being truthful about the missteps. Senate Bill 163 holds employees accountable for the intimidation and fear that they try to create when they engage in union busting. Please pass SB 163 to protect workers' rights in Connecticut. Thank you very much.
Thank you, Ms. Brown. Questions or comments from the committee? If not, I want to thank you for being with us and sharing your story. Lynette Singleton.
Good morning. I'm here in support of SB 63. And good afternoon again. Oh, excuse me. Senator Whitfield and Representatives Strom and members of the committee. My name is Lynette Singleton. I live in New London, Connecticut. I am a direct support professional at Sunrise, and I also am a PCA and have worked for Sunrise for 23 years. And I come before you today to ask you to support the Senate Bill 163 and tell you about my experience striking Sunrise Northeast worker last fall. In my role as a direct support professional, I care for 3 individuals with intellectual and physical disabilities. I cook for them, I clean up after them, I give them their medications, help them with their hygiene, do activities with them, help them socialize. I absolutely love my job because the people I care for have become like family to me. But my bosses at Sunrise decided that workers like me didn't deserve the funding that we fought for so hard during the last year's legislative session. So my coworkers and I voted to go on strike, and we walked out on October 12th. Instead of trying to get to a solution with the workers, Sunrise Northeast hired union busting firm Jackson Lewis for thousands of dollars. While we were on strike line, Jackson Lewis advised their clients on all kinds of things they could do to break our strike rather than to work with us to end it with a fair contract. They sent out many communications with outright lies to members, claiming to them that they were offering significant increases and that the union was lying about their proposal. They harassed and intimidated workers who were on strike for a better life. They sent multiple letters, texts, calls, and emails to give us while we were out, telling us flat out lies about the proposal. They also sent around a video where a woman none of us ever met claimed to work alongside us. The vast majority of the upper management is white, and we believe that they chose a Black woman for this video because most of us are Black and brown. We have never seen or heard of this woman, and yet she claimed she worked alongside of us for years and proceeded to tell us that we should accept the bad offer management had on the table and resume working. When we called them out for that in the comment section of the video, they deleted all our comments and eventually disabled the ability to even leave a comment behind. That should tell you what Jackson Lewis thinks of workers like us, people who were just trying to get a better life for ourselves and our individuals. They think they can lie, they think they can fool, and they think they can intimidate workers like me. If this is what they do when we have a strong union, imagine what they do to workers who do not yet have the power or protection that a union can bring. Please pass SB 163 to protect workers' rights in Connecticut. Thank you.
Thank you, ma'am. Questions or comments from the committee? If not, appreciate you being with us and sharing your story with us. All right, I think we have Senator Kelly with us. Senator, good to see you.
Likewise, Mr. Chairman. And thank you for the opportunity to address the Judiciary Committee. I'd like to thank Chairman Winfield, obviously you, Chairman Staffstrom, as well as Senator Kissel and Representative Fishbein and all the members of the Judiciary Committee. I'm here to testify in support of Senate Bill 164, an act concerning state agency compliance and probate court orders. The bill would make probate court orders decrees binding on state agencies when the probate court has statutory jurisdiction over the subject matter. The bill aims to protect the state's most vulnerable residents. Working in the field of elder law, I have all too often seen the most vulnerable individuals forced into financially difficult situations in order to receive state services because a state agency has wrongfully disregarded a probate court order. Probate court is the people's court. The power and jurisdiction of probate court arise in the Connecticut General Statutes. The jurisdiction runs concurrent, I think this is important, concurrent with the Superior Court, which is a court of general jurisdiction. Included within the jurisdiction and power of the probate courts are, among other things, the powers to determine title and rights of possession and use in and to any real, tangible, or intangible property that may constitute part of any trust or any estate. Also, to determine the validity and construe the meaning of any will or trust agreement, and to apply the doctrines of cypre and approximation. At times, the probate court has exercised these powers to determine title to property, but such determinations were not recognized by the Connecticut Department of Social Services when the department subsequently determined eligibility for Medicaid. Such differing opinions as to title has led to unfair results where individuals were denied the right to the beneficial use of property by the decree of the probate court because they did not own the property, but were then denied Medicaid eligibility for a period of time because to the department's differing opinion on title. Attempts have been made by this General Assembly to ensure consistent results. The most recent was Senate Bill 940 from last year, which passed both chambers, but was subsequently vetoed by the governor. As a result, we continue to see a problem in the system which negatively affects poor, vulnerable, and disabled individuals. I have written to the Center for Medicare and Medicaid Services, CMS, to seek their guidance on this specific issue as to whether federal reimbursements would remain in place should this law become implemented. I am waiting their response. I have tasked my staff with following up, mindful of the short session deadline, but would ask that the committee move the bill forward, get it out of committee so we can continue to work with CMS and hopefully resolve this issue for the betterment of the people of Connecticut. Thank you once again for raising this bill and having a public hearing and offering me the opportunity to address the committee today.
Thank you. Senator Kissel.
Thank you very much, Mr. Chair. Senator Kelly, it's great to see you here at the hearing. Well, I think that you've caught their attention this round because the commissioners of both DSS and Developmental Services testified in opposition, specifically to some of the arguments made by DSS, and in particular counsel, who I have no problems with personally. He's been on the job he transferred after 20 years of public health to DSS. So he's been there a couple of years and he says he hasn't really seen these cases, but you described the current system as unjust for essentially or especially poor, struggling individuals and people in that sort of spectrum, whereas they sort of characterize people gaming the system or seeking out unfair advantages through the probate court and having the wherewithal to hire counsel sort of as a predicate to then having something transpire in social services to their benefit. And those are totally diametrically opposite kinds of characterizations as to what is going on out there. And I'm just wondering how you respond to that characterization.
Well, I mean, first and foremost, I worked in the system. The system, because it didn't represent the people, and by the time people got in contact with DSS, they didn't have the opportunity to know the rules because DSS wasn't explaining it to them. So in essence, when somebody would approach the Department of Social Services, and for instance, if they didn't know how to lower income because of a pooled trust, if you were looking for community-based services, Department of Social Services wouldn't help that client. So there would be a wrong door. If the person that came before the department didn't have and understand the law, and let's be honest, in this area of the law, Medicaid is very complex. It's as challenging as the Internal Revenue Code. The difference is that the Internal Revenue Code publishes periodically, and we know when that happens. Medicaid policy is more ad hoc. So it's just as complex, but not as conformed. And so mindful of that, and knowing that by the time people got to where they were, I went to law school at night, got my law degree, and continued to practice in the area of elder law to make sure that people understood what the law entitled them to. This is an entitlement. Unfortunately, what you have is, depending upon what you do, and in this case, if you brought an application to determine title in the probate court and got a determination, or took it to the superior court, which has concurrent jurisdiction, the ESS would accept the concurrent jurisdiction of the superior court, but they wouldn't take the concurrent jurisdiction of the probate court. And that's a trap for the unwary. And that should be something that, a state agency should be informing their citizens on. So we want to make sure that when something is done in the probate court, that it has the full force and effect, and that there isn't any, different treatment depending upon which court you went to, nor because you relied on a probate court order that you rely to your detriment. Because what they said was okay on one day, when you finally get before the DSS, they say they're not going to give it any credit and not accept it.
So just to follow up, you said you came from that milieu. Did you ever work for DSS, or I'm not all of us are aware of your background, and you have a level of experience with these issues that most folks don't, even if they have a probate experience?
Well, when I got out of college, and I guess people can do the math. Yes, I worked for the Department of Social Services in the Bridgeport Regional Office for almost 14 years before practicing law. And as an investigator for the department, I largely worked within the context of the Medicaid agency, the Medicaid rules and eligibility, which also took us to, I'm going to say, working very closely with the Office of the Attorney General and appearances in the probate court. So I know that I've heard a lot of the department's testimony that it would be an unfair burden and disadvantage, but we used to regularly go over to the local probate courts in the greater Bridgeport area. You became very, I'm going to say, comfortable with the clerks of the court, understood the files, reviewed the files. And while you look at them, most of them you look at and you recognize, okay, there's nothing really at issue here. And then there's some where you're like, oh no, there may be an issue here. You give your eyeball on the file. And this is before I practiced law. And then if there was a legal issue, you could make the referral to the Office of the Attorney General. That was very easy to do. It would just take some time to go down to the local probate court, review the files that you had to review, look them. The clerks would give you the file and you'd look them over. And if there was an issue, you'd forward it on.
So it just strikes me, and I'll leave it at this. Clearly, you don't have a grudge or anything against DSS, but it sort of tells me that there was a way of doing business back in the day when you were working 14 years for the Department of Social Services, where you actually physically went to the probate courts and actively participated in a lot of these determinations. And it seems like somehow over this time span now, they have moved away from that paradigm, and they don't want to have anything more to do with that. And maybe it's going to mean hiring more attorneys or staff or just going out of their way. But it seems to me, I would agree with you that the best interests of the public are served by having that intimate knowledge and the close working relationship with a variety of probate courts out there. If there has to be notice and ability for folks to show up, I'm sure that can be addressed. The last point that I'll make is this. We asked, or actually Senator Winfield asked specifically the commissioner of DSS, even though DDS also testified in opposition, but said they're willing to work. I don't know if there's a middle ground here or not, but the commissioner said she didn't want to foreclose that opportunity. It is a short session. I know that the three of us had that meeting last year. I don't know how fruitful it would be this year, but I'm hoping, given the unique experience you have with this process, that our colleagues in the legislature would realize that this isn't something that you just pulled out of the air, that this is something that you know in your heart of hearts through your life experience and working for the department itself. Now you're in a different role, and you can make sure that the best practices are followed going forward. Would that be a correct, somewhat characterization? I know it's broader than that, but.
Yes, and I'd be more than willing to have further discussions with DSS. I'm also mindful of the difficulty of the job of DSS. It is no doubt a difficult job, not only administering that department, but as caseworkers on the line, handling the need of the clients that come before them. So I do not want to displace DSS as the Medicaid agency, nor their province over Medicaid eligibility determinations. What I am trying to reaffirm here is the statutory authority of probate courts to do things such as construe and interpret a will or trust. That is a job that is uniquely a job of the probate judge. And bear in mind that the Medicaid program is a joint program administered cooperatively by the federal government with its states. You have a federal rule, such as you need to be a U.S. citizen, you have to be medically needy, categorically and financially eligible. So there's certain national rules, but then where it's administered cooperatively is where the state-based laws come in, and that would be property law. Good example. In Connecticut, if I were to be a single individual moving from their house in Stratford to a nursing home and needing Medicaid assistance, my house in the state of Connecticut would have to be sold and either the department lien it and get reimbursed or be used for the payment of my medical care. However, if I was a resident in the state of Florida, the Florida has a homestead exemption embedded in their state constitution. And so a home in Florida is exempt because the state-based property laws are different. And that's what we're doing here is the probate court has this right to, I'm going to say, review and statutorily construe instruments because sometimes, legal documents are not as clear and somebody needs to interpret that. The probate court by, the General Assembly is that agency that does that. So those decisions need to be given full faith and credit, just as the decisions of Medicaid or DSS as to Medicaid need to be given full faith and credit. So, I respect what the DSS does and the people who work for that department. It's not an easy job.
Well, Senator Kelly, I'm really happy that you're the leader of our caucus and you haven't given up on this proposal despite Governor Lamont's veto of the bill that passed last year. And certainly, I always find it illuminating that when we have public hearings, we have individuals with unique perspectives that are informed by life experiences that the rest of us don't have. And certainly your background with the department in and of itself for well over a decade gives you a level of expertise above and beyond that of a very active legislator in the state Senate. So thank you, Mr. Chair, and thank you, Senator Kelly.
Thank you. Representative O'Day.
Thank you very much, Mr. Chair, and thank you, Senator Kelly, for coming before us. I read your testimony. This is not an area of the law that I'm familiar with, and so I don't know if you heard the testimony of the Commissioner and Attorney Antonetti. Did you get a chance to hear that, Senator Kelly?
I did.
So, and as our good ranking member just mentioned, that he's been on the job. Attorney Antonetti's been on the job for only a couple of years. You sound like you have a lot more familiarity with these issues and been dealing with them for longer. One of the comments the commissioner made was we'd be the only state that would have this legislation. I didn't want to pry too hard on, but our state is somewhat unique with the probate courts. How would you respond to the fact that we're the only state that would have this legislation?
Well, I think that, quite frankly, I'm a little taken aback that we live in a state where we have a state agency that doesn't follow a court order, that actually disregards a court order. And I think the actual reason that we're the only state is because I bet you there's no other state in the nation where you have state agencies disregarding court orders. That's the necessity for this bill, is that it's unprecedented, but that's why we're where we are, because even when the Supreme Court of the state of Connecticut decided the Valeri matter, the word court was in the federal statute, and our Supreme Court said that was applicable to probate court, because probate court is a court. So that's why I think we're the only state, because we're the only state that has an agency that's looking at Medicaid eligibility in this adversarial relationship.
Well, thank you, Senator Kelly, very much. I don't know if you had any conversations with the governor's office about after his veto, but I'm not sure what's happened since. But if have you heard anything back as to what might change?
Nothing at this point.
All right. Thank you very much, Senator Kelly. Thank you, Mr. Chair.
You bet.
Representative Pavlak-D'Amato.
Thank you, Mr. Chairman. And thank you, Senator Kelly, for your testimony and this bill. I, much like Representative O'Day, I don't have elder law experience. I can only look at it from a, law school and general attorney perspective. And I think other attorneys would probably agree, the department to me is more of a party. The court's role, of course, is to interpret. And I agree with what you just said. You kind of answered some of my questions that, and I see it, by the way, in other departments and in other areas of the law where the department is overriding or not recognizing court orders or have the authority to override that, which I can tell you does not happen in Florida because I do practice there as well. So that would be a reason why they don't have a statute down there or have the need for this bill down there. I know I didn't listen to all the testimony before because I did have a client, so I will review that. I think he raised federal concerns, but I think part of the concern was, and Senator Kelly, you kind of referenced going down to probate court, looking at files, which I know for me, at least realistically, is not something I can, especially as a solo practitioner, but I'm sure it applies to the department, just you know, getting up and going and spending half a day doing that. And I know there are limitations as to what is put online, but do you think it is possible, if there was recognition, or let me ask, is there anything that is filed in court records or in public records that would puts everybody on notice as far as some of these? I know you mentioned title issues. So is that currently the practice, or do you have to go look in the probate court file?
Well, look, I think if you want to bind a party, it's necessary to provide notice to that party, to give them an opportunity to participate in whatever is occurring at the court hearing. If you don't have knowledge and you don't get notice, then I can understand the party not adhering to what the court gave. But if you did get notice, and you didn't go, or you did go and didn't work out the way you wanted it, that's a different story. So I think notice would be a requirement that you'd want to make sure the department had, so that they could come and have the opportunity to participate. Because I know if you just sent them, if they didn't get notice, then how are they going to know what's going on at the court?
So can you provide an example, by the way? I think you had mentioned about land and title. If you could provide an example, because I'm not familiar with this, maybe it would be easier for the public as well to understand than what, like, an example of an issue is that you're having.
Sure, I'll give you two different examples. The first one would be someone developmentally disabled, and you have a parent, and this, I'm going to give you examples of cases that I know of. A parent who, there is a line of cases in the state of Connecticut that deal with supplemental support trusts. And in this case, a supplemental support trust in a will. So they followed Riley, they filed Zeoli when Zeoli became law, and they followed the Kolodny case when Kolodny became law. And the document was basically a supplemental support trust. But embedded in the document was what I'm going to call precatory language. So going back to your law school days, that's language that's included in the trust, but it's not the authority that the trustee would have. It's more guidance. So there's some precatory language that explained what the trustee would want to, I'm going to say, how when they had this supplemental support and the ability to withhold distributions, what they could be guided by in making some distributions on. The probate court deemed the trust to be a supplemental support trust. However, when the family then applied, because DDS required them to apply for Medicaid, Medicaid determined that that was a general support trust and disregarded the Kolodny language, which in this case was sole, absolute, and uncontrolled discretion vested in a trustee. And so you had a situation where then the family, if they disagreed, would have to go to a fair hearing, and I'll discuss that more, and then to Superior Court. Well, there was only maybe $40,000 in the trust. And you know that DSS, you've seen their adverse position with regards to this. They were going to take this right to the Connecticut Supreme Court. So the proposition to the family was, I'm probably going to have, $70,000, $100,000 in legal fees over a dispute of $40,000. And while the case is pending, my Medicaid application is denied. So you're in a facility paying privately. So that could be another $100,000. So when the family is confronted with $100,000 of legal fees, $100,000 of institutional care over a $40,000 dispute, they ended up just cashing in the trust and making the issue go away. But that disabled client was diminished because now they didn't have what mom wanted. And she clearly amended her trust every time the Connecticut Supreme Court enunciated a new standard to make the trust supplemental. they modified the documents accordingly. So now this individual that had no parents, a disabled child, was now on Medicaid without a supplemental source of additional benefits so that they could have just a modicum of a better life. And so the department made them cash that in. So that's one area. Just before I get to the second, as to the fair hearing, this is another issue where it's really not a fair, I'm going to say process. They have an Office of Administrative Hearings and Legal Counsel. And the legal counsel advises caseworkers on how to approach many of these issues, especially when they're complex like this. And that same legal office advises the hearing officer. So if somebody comes in with a trust like this, that lawyer is going to advise the caseworker, deny that because it's a general support. You take it to the fair hearing, you present the same issue. The hearing officer is going to rely on that same legal office who's already made a determination that it's available. You're going to get denied there. When you take it to the superior court, you'll then run into the problem of being on the outside track because the department, is going to have, as the state's Medicaid agency, the presumption that they know how to determine eligibility. And part of the court's review of an appeal from an administrative agency is whether the agency acted arbitrary and capricious. And so it's very difficult for people, particularly people without means, because remember, these are people on Medicaid or approaching the asset limit of $1,600 to face a department that can litigate it through to the Connecticut Supreme Court. The second example I'll use is a situation where, let's say I have a vehicle, let's call it a 1964 Chevy Impala. It's a classic car, and that's in my name. And in 2014, I decide to sell the car to you. And, we do everything, but the car stays in my garage. You give me the money, and that's the way it is. Then we come forward to last year, and you realize I never gave title to you. So we approach the probate court and we show that you paid me or the money for the car. I just never gave you title. And then I put the car in your name at that time. And then let's say we do that in January, and then in July, you have a stroke and you need to apply for Medicaid. And as part of your Medicaid application, you show that that 64 Impala was owned by you. Let's just say it's worth $20,000. So they make you spend that car, you sell the car, take the $20,000 and pay for care, which will be a little bit more than a month. Let's call it a month and a half of nursing home care. And then Medicaid picks up a month and a half later. I then have a heart attack and need to go into nursing home this year and in January. And now part of my present Medicaid application, they stumble across, in January of last year, you got this probate court decree that shows that you transferred that Chevy Impala. We disagree with that. We're not going to buy that court order. That car was in your name in January of last year. So we're going to say that was an improper transfer and now deny Medicaid eligibility for a month and a half on me. And see what happens here is they end up getting 2 bites at the apple for the same asset. And that's not fair to the people in need of assistance. And that's what this bill is aiming to try and clean up, is that the ESS does have the right to make sure that one person, has that asset, but they shouldn't get to have the opportunity for 2 bites at the apple.
And I've, I guess the only way I can understand this actually is because it parallels actually bankruptcy court, their rules and what they consider to be 2 bites at the apple as well. So I will look into that. That might be helpful for the committee. I know it would be helpful for me to see. And I know that's a court versus an agency, but I do see the struggle between, you know, upholding what the federal guidelines are or rules and laws as opposed to, you know, a state decision, whether it be court or otherwise. So I'm going to look into that, and I'd be curious to see what happens there. And by the way, when you're talking, I thought you were talking about CHRO for a second, because everything you actually were discussing before sounds very similar to their agency and, you know, the issue with the $40,000. So it's an interesting, very interesting subject. So I'll be doing more research, and but thank you for your testimony and for bringing this bill. Thank you.
Thank you.
Thank you, Representative. Are there comments or questions from other members of the committee? Comments or questions? If not, Senator Kelly, it's good to see you. Thank you for joining us this morning or afternoon now.
Well, thank you, and I appreciate it. Thank you, Mr. Chairman.
Thank you. Next, we'll hear from Melissa Linden, followed by Sasha Koppel, and then Terry, I think it's Home. So Melissa Linden, I saw your name.
Hello.
Hello, you may testify.
Yes. Can I separate? There was a woman who was a marshal who had made some statements. Am I allowed to retract that separate from my statement? Because they were kind of defaming. I view them.
Ma'am, you get your 3 minutes in which you can testify how you choose.
Okay. I want to say that Lisa Stansfield is absolutely a thief and a liar. And go look at the case. If she's so honest, then why hasn't she put her return in? How did she eject me on eviction papers? And actually, there's an absolute case before her with my husband where she lied in court about his residency. He's a foreign national, never been to Connecticut. She put in court his abode was my parents' property. Now banks think he lives in the States, and he's getting audited from her, and she's refusing because she's a thief and she jumped on my property. I'll be putting video up for everybody to see Lisa Stanfield's actions. She wants to hide. Nobody's harassing her. I've been stuck in Canada for 2 years. I have attorneys, everything.
Ma'am.
Well, that's one thing, but mine is about the probate. I'm here today about the probate orders. Nobody listens to decrees. And because of that, all my businesses and everything were stolen. You need to look at the land records. You need to look at the cases and show that, because I shouldn't wear judges' crimes or mistakes. None of you guys want to do anything about it. Justice Peoples closed his court for 3 months with no right or no direction from Ned Lamont. You know what? Justice Taylor didn't listen to Justice Degree that I was a fiduciary, nor did Kalau. Didn't make me a party to any of my mom's cases or bankruptcy affairs. That way, everybody was allowed to steal everything I loaned. I'm not crazy. I was emotional 2 years ago. And as far as being a pro se litigant, I shouldn't have to. I'm going to reiterate, never had a mortgage. So why am I ejected? Never had a rental agreement in Connecticut. So how did a guy I've never met evict me, and how was I attended who I've never met and didn't have a rental agreement, and he gained a house after my mother's death that I have title insurance and the deed to? How did you let him gain a house on an affidavit? You know why? Your records are being altered. You know what they do? They alter the dumps and use cron jobs to execute them. I've told you in the court. And I'm being aggrieved by fraud, and everybody looks at me like, okay, that's a well, but you know what? I don't have to wear this. We're at times, you need to address Lisa Stanfield, and her marshal hearings and all those complaints need to be public so that people can hear how marshals conduct themselves, how they weaponize and terrorize constituents and gain their property unlawfully, because in the United States, we're born with liberty, justice, fundamental fairness, equal justice under the law, and we're not crazy. There's nothing that makes me crazy. Look at my background. I've Mandela that backs me, and Gandhi.
Your time has elapsed.
Yeah, and I'm sure there's nothing.
I'm going to Ms. Linden, please. I'm going to see if there are any questions or comments of the committee. Ms. Linden, did you provide written testimony?
I'm going to provide my testimony, but I support Rep. Kelly. He said it much more distinguished. And I just want to say something to you guys. I don't find this your fault. You guys put the programs and the money there. It's the people who are working in them, like the clerks and everything, that are misguiding the people that are running them. And I don't think reps should be accountable. I think these agencies, the Judicial Review Committee, I went to them. They're not accountable.
Ms. Linden.
So I'm just saying that. I'm just saying that as bones to you guys.
I appreciate it, but I don't want to allow you to keep going, because then I should allow others to keep going. When you submit your written testimony, I will definitely read it. Thank you for joining us again today. We will next hear from Sasha Capo, followed by Kerry, I believe it's Hone. If I mispronounce your name, I am sorry. And then Lincoln Woodward. Is Sasha Capo here? Sasha Capo. Carrie Home? Home?
Hi, how are you? It's Hona. And I think you've gotten closer year after year, Senator Winfield, so thank you. My name is Carrie Hona. I am Executive Vice President with the United Food and Commercial Workers Union, Local 371. And we proudly represent about 8,000 workers throughout Connecticut and Western Massachusetts. I'm testifying in a coffee shop, so I'm getting an audience now. So we organize workers into our union all the time, and I've given testimony several times over the years about Senate Bill 163 or its predecessors. And with each speech, the message doesn't change. I just get another year or two of stories of captive audience meetings and how they've affected workers trying to organize a union in our state. According to a Gallup poll taken last year, support for unions has increased to 65%. I think the last time I spoke to you, support was about 48%, and in 1995, it was 30%. So support for labor unions has grown, and yet our membership still is at 11.6%. So one of the biggest reasons why membership remains so low is the fact that employers intimidate, coerce, and lie to their employees in an effort to get them to vote against joining a union. The employers communicate nearly all of their anti-union messages in captive audience meetings, either one-on-one or in a group. Prior to working as vice president, I was a union organizer and organizing director of our union. And I submitted written testimony. So since I do have lots of background noise, I'll let you guys read through them all. You did hear from Roger Weldon, who's in one of our most recent organizing campaigns. And the parent company for his company is called Glambia. They're from Ireland, and they are 100% union there. And we spoke to our union brothers and sisters, and they gave their support overseas for our organizing campaign. And despite that, Glambia has been adamantly anti-union and does not represent the workers in the workers' rights in Connecticut the way they do in Europe. And it's simply because laws like this allow them to fight workers' desires to join unions. So I listed about 6 or 7 of them in my written testimony, and I'll just say that captive audience meetings during union campaigns is the rule. It's not the exception. Many of the promises and threats made in these meetings are against the law, but for employers, it's a risk worth taking, because the worst case scenario is you have a rerun election, and maybe if you fired some workers, you've got to reinstate them and give them back pay. By the time those remedies are reached, the issue is long settled. The company has long won their union election, and maybe the union's gone away and they've been able to continue to operate union free. So I really strongly support this bill, Senate Bill 163, and I really hope that this is the year we're able to get it passed so that workers in our state can really choose whether to join a union free from intimidation. Thank you.
Thank you, opponent. Are there comments or questions from members of the committee? Comments or questions, Representative Porter?
Thank you, Mr. Chair. And Carrie, just wanted to say good to see you, and thank you so much for making the time to be here and give your testimony today. I think we're hearing a lot from the workers as well, which really helps to validate the importance of getting this done this year and the sense of urgency to bring back dignity. Thank you. Thank you, Mr. Chair.
Thank you, Representative Porter. Comment or question from other members of the committee? Comment or questions? If not, thank you very much for joining us and struggling through the background noise.
Thank you. It was so quiet here for a long time. Thank you.
Next, we'll hear from Lincoln Woodard, followed by Anastasio Savitas and Edward McCreary. As Lincoln Woodard. And
Thank you, Chairman Winfield, members of the committee. It's an honor to be back before you all. My name is Lincoln Woodard, and I'm here on behalf of the Connecticut trial lawyers to testify in support of Senate Bill 204, which is an act concerning damages caused by the negligent operation of a motor vehicle owned by a political subdivision of the state. This bill is a much needed clarification designed to do nothing more than make clear that operators of motor vehicles that are owned by municipalities are held to the same standards as those operating state-owned vehicles. We all know motor vehicles are dangerous. In 1949, the state, who is otherwise immune, waived immunity by passing a particular statute for injuries stemming from the negligent operation of state-owned vehicles, whether it be plows, state police, or any other type of vehicle. It was codified in 52-556, and with good reason. We want to protect our public and others using our roads to ensure that drivers of state vehicles also operate safely and reasonably and are not immune from their conduct. If that's the law for state-owned vehicles, then why wouldn't it also be the law for municipal vehicles? And I know you heard comment from Attorney Gerard for the municipalities earlier, but until about 5 years ago, it was the law. The municipalities in their oral testimony suggested that the immunity laws have been in place for years. And yes, that's true, but the court decisions extending this, what we call discretionary conduct, to police chase cases and other municipal cases, both within the emergency response statute and otherwise, is brand new. 14283 is the emergency response statute that I think was referenced earlier, and it has language in it that this body created to also make sure that there are guideposts for emergency vehicles during chases or when they're responding to calls. It states that if they're in an intersection with a red light or a stop, they can proceed through they can run the red light or the stop sign, but only after slowing down or stopping to the extent necessary for the safe operation of a vehicle. And in addition to that, subsection D of that same statute says that the section shall not relieve the operator from the duty to drive with due regard for the safety of all persons or property. So if you're chasing someone or you're on your way to a call, you still have that legal duty. And in a recent court decision, this phrase was deemed by the Supreme Court to be discretionary acts. And so that this due regard duty is essentially granted municipalities immunity, and they can simply, that duty is gone.
Attorney Woodard?
Yes.
I'm
sorry, I'm out of time.
Yes.
But I think to make clear, we're not expanding the tort law for municipalities. It's just to codify and clarify what's been the law for many years. And I apologize. I'm happy to answer questions.
Thank you. Comment or question, Senator Kissel?
Thank you very much, Chairman Winfield. Attorney Woodard, great to see you again after a while. Appreciate your testimony this afternoon. Probably the part that struck me the most about the testimony in opposition, because again, you're saying it's a clarification of past practice. They're saying, no, it's been this way for 40 years. But this whole notion that if we go forward with this legislation, I know you've characterized it as merely putting into statute what had been the case, but directly the response of yourself and the trial bar to the fact that it would drive volunteers away from volunteer fire departments and emergency services, that would be a negative consequence. And how would you address that?
Well, I think that a volunteer, if we're talking about an emergency response, if they're responding to an emergency call and they have their lights and sirens on, they are allowed to violate. That's the whole purpose of the statute. And that statute was not intended to simply apply only to state vehicles. It was passed, it's been amended and worked on by this body to try and create the balance of when they can run a red light. They do so, but they have to stop and make sure that it's safe to do so. And it's not going to create that. This has been the law for years. It's never been raised as a discretionary act that would, just create immunity for the drivers. About probably 10 years ago, we had a case with a police officer, lights and sirens on, ran through an intersection, a municipal police officer, and was involved in a very serious collision. And we were claiming that he violated that statute. The immunity issue was never raised. It's just come up as sort of creative lawyering that's come along. And when the courts are lining up the discretionary immunity language with the discretion that's in that statute, they're saying that's a discretionary act to act for due regard of others. But the practical effect of it is all of that be careful language that's in the emergency response statute, it completely goes away. They can act with impunity because they're going to have summary judgment granted. And so it's not a question of volunteer or not volunteer. This has been the law. The litigation isn't going to change by the passage of this statute.
Well, Counselor, you know that it's great. I just can't reiterate how great it is for me to see you and to hear you testifying. And I think it's important for my colleagues to hear that the trial bar is not trying to take advantage of a certain situation or bend the rules to make lots more people exposed to potential liability, that this is essentially codifying what had heretofore been the law and the practice. I appreciate the fact that you said that it's essentially somewhat in response to creative lawyering on the defense counsel side in raising this up as a specter. And it's more like this legislation or this proposed legislation is more of a head them off at the pass kind of thing. And I'm sure the trial bar appreciates creative lawyering, but not in a case where it actually is foreclosing some individuals from attaining justice, which is what we're essentially all about. And so, the sky is falling down, I think I'm sure that testimony was offered in complete good faith, but I don't necessarily see this as doom and gloom as it was put out by the detractors. And I'm very sympathetic to the position that you put forward, that we're merely codifying something that heretofore folks had been able to rely upon. And I don't think that we're in any danger of losing our volunteers, whether it's firefighters, EMTs, or anybody else that serves our communities. So again, I want to say Lincoln, but Attorney Woodard, thank you so much for coming to testify. And thank you, Mr. Chair.
Thank you, Senator.
Thank you, Senator Kissel. Representative Blumenthal.
Thank you, Mr. Chair. It's great to see you, Attorney Woodard. Thanks for your testimony today and for your work generally. I had two brief questions I wanted to ask you. One, in regard to the specter of volunteers potentially being liable in a way that they weren't before, are individuals who would be potentially involved in the acts that would be sued under, are they generally indemnified, or are they pursued in their individual capacity for personal assets or something like that?
No, first of all, the action would be against the municipalities and involve certainly the insurance, or if there is insurance of the municipality, just as it's always been. It's no difference whether you're a volunteer or not. But no, they're not going to be losing their homes or anything like this over this type of conduct when you're acting for a municipality in that capacity.
Well, thank you for that answer. It sounds from it like it's not really the individual, regardless of whether they're a volunteer or employee of a political subdivision, that's going to be pursued. It's really about the municipality. And would that be fair to say?
That's correct. Yes.
And I guess the other question is, I understand that a municipality wouldn't want to be subject to potential liability for anything if it could have the opportunity of that. But other than simply not wanting to be subject to accountability in the courts for negligent acts of someone acting on their behalf, can you think of any principled reason why a vehicle owned by a political subdivision of the state, a municipality, should be treated differently in terms of accountability for negligent acts that cause injury, different than a private individual who's in their own vehicle?
No, I mean, I think that that's really the point of 556, a lot where the state, it was, the state saying we're going to waive immunity for state-owned vehicles because we want to make sure that that everybody's operating reasonably and safely on the roads because it affects the whole of public safety. And this emergency response statute, to think that there is no consequence for not having due regard for the safety of others on the roadway because that's going to be deemed discretionary is really not, it swallows the whole notion that there is going to be any type of balance there. And the extension of it, if you look in many of our motor vehicle statutes, like the left turn statute, it says you have to make a left turn only if it is reasonably safe to do so. And so that hasn't been addressed yet, but that's certainly discretionary, and so is practically all acts of driving. So
I think it's right.
I'm sorry?
I think it's a right turn.
No, I'm talking about if you're making a left turn across traffic.
There we go. All right. Thank you, Counselor.
42 is what I meant. If you
Very good.
A lot of car accidents happen as people make left turns, and it says it has to be done with reasonable safety. Well, if you're in a municipal vehicle, you can say, well, determining whether it's reasonable to pull left is the same thing as whether it's reasonable to go slowly through an intersection or not. And so it's also discretionary, just like many of our motor vehicle statutes have that type of language in it. That's all I was intending to say.
Sorry, Representative Blumenthal.
No problem, Senator Kissel. Thank you for your testimony, Attorney Woodard. I found it very helpful, and I do have the same concerns that you do about exceptions to allowing the rule and losing an important tool of not only allowing individuals who are injured to get justice and recompense, but also removing an incentive for political subdivisions of the state to ensure that their employees, volunteers, et cetera, are behaving in a responsible manner on the roads. So thank you, Attorney Woodward, and thank you, Mr. Chair.
Thank you.
Thank you, Representative Blumenthal. Further question or comment from the members of the committee? Further comment or question? Seeing none, Attorney Woodard, thank you for joining us this afternoon. Have a great day.
Thank you very much.
Next, we have Anastasios Savidas, I believe, unless I've messed up your name, and for which I will apologize. Edward McCreary and Venus Lebo.
Thank you, Chairman Winfield. You didn't mess up my name. My name is Andy Savides. Good afternoon. Good afternoon, Chairman Staffstrom and the entire Judiciary Committee. Thank you for allowing me also the opportunity to speak today. I am, similarly to Attorney Woodard, speaking on behalf of the Connecticut Trial Lawyers Association in support of three bills that we've put forth: HB 5237, which is the Uniform Interstate Deposition and Discovery Act, SB 204, that Attorney Woodard just spoke on, and House Bill 5235, which deals with the calculation of prejudgment interest on an offer of compromise. And that last one is going to be my focus today. You heard earlier from Attorney Casper, and you just heard from Attorney Woodard. So what we are seeking to achieve through House Bill 5235 is to reform the way in which prejudgment interest is calculated in this state when it applies. And we believe doing that will make it fundamentally fairer for the person who's been harmed and will have an impact on getting more cases settled earlier in the process. The goal of any prejudgment interest statute is to encourage not only early, but reasonably fair settlements. Most cases, and I deal primarily in injury cases, but most cases settle when one of two things happen. And they settle only fairly and reasonably when you have either a deadline, like an upcoming trial date, or some other pressure that's applied, like our prejudgment interest statute, the offer of compromise statute, to get the case to settle. The deadline itself, a trial date's at the end of the case, and we want to encourage settlements to happen before then. The prejudgment interest statute, on the other hand, provides the pressure to get the cases settled much earlier. And, more so in the last few years, certainly with what's been going on, most injury cases go something like this. You have the harm that happens, there's an injury, there's treatment that happens, the treatment concludes, you make an attempt to settle the case without having to file a lawsuit, and nothing happens. You either get no response or you get a really, really low, I would say, insulting offer in the case. And then you have to file a lawsuit and the case progresses, not much has changed, you get some depositions done, and it's usually not until the case is called in for trial that a realistic offer is made to settle by the insurer, the defendant. That's probably 95% or more of the cases that that happens in, whether it's a motor vehicle crash, a premises liability, a fall down situation, an assault of some kind, a dog bite. Those are the great majority of the cases that are affected by this. And the one thing that you have to remember is that in order for the interest to attach in the first place, a number of things have to happen for the plaintiff. You have to file the offer of compromise. You have to actually go through with the trial. And then you have to actually prevail by equaling your offer of compromise number or surpassing it. And the reality of all those three things happening in any given case is pretty small. You probably have a better chance of being struck by lightning than having that happen. There's not been a lot of litigation about, offers of compromise.
Your time elapsed, if you could summarize.
Okay. Yeah, so what we'd like to see is that the offer of compromise prejudgment interest relates back to the date that the harm happened and not some arbitrary date when the lawsuit was filed. That's the bottom line, because it's fundamentally more fair and there's no other rational basis not to do it that way. Thank you. I'm happy to take any questions. Sorry.
Representative Fishbach.
Thank you, Mr. Chairman. Good afternoon, Andy. Nice to see you again.
Nice to see you too.
Andy, I just want to drill down on the procedure with regard to this. So now the scenario that you gave us, a motor vehicle accident has occurred and treatment has ensued. Treatment goes a certain period of time. During that time period, from accident to conclusion of treatment, which could be, let's say, a year of treatment, is there any opportunity for the insurance company to, well, in most cases, I think you aren't going to go to the insurance company if you're representing the injured with a number, right? Because you don't know what the case is worth until treatment is over.
For the most part, that's true, but there are, unfortunately, a number of cases where you've got a serious injury. And, as you guys all know, the minimum auto insurance liability limits in Connecticut are only $25,000, despite our efforts to raise them in the past. And because of that, very often you have a case where somebody's got a serious injury and there's a very limited insurance policy where you can, make a demand for them to pay their policy limits. Whether that's because there's no other insurance or avenue of recovery, or you want to move on to pursue underinsured motorist coverage. So there are several opportunities that present themselves when you have limited insurance limits, which unfortunately a lot of people are driving around with.
Oh, no, I don't disagree, but certainly on a case where, let's say, somebody loses a limb, significant case, in my experience and more than likely yours, you go to the insurance company, there's a $25,000 policy, somebody's lost a leg, you're getting a check, right?
You should.
So, yeah, you should, right? And the cases that I've seen, the insurance company usually ponies up in that particular situation. But let's say it's a 100, 300 policy. Soft tissue injury, get some treatment over a 6-month period. During that period of time, more than likely, you're not going to make a demand of the insurance company. At least that's my experience.
Of course. Yeah, that's true.
So at some point, a demand is made and the insurance company believes it to be unreasonable. And I've been the subject of these low ball offers. So I know, it's a $25,000 case. They offer you $4,000, go away. I understand. but then the matter goes to trial, and this pretrial, judge throws a number on it, all that stuff, and still they can't go get together. We have a trial, and the OC was filed. Why is it fair, just, and equitable for the calculation to include a period of time where a number is not on the table?
Because ultimately the defendant or the insurer has the right at any stage of the proceedings to settle the case. It doesn't have to be at the beginning, doesn't have to be at the end, could be any time in between. And when there's a reasonable offer to settle the case made, doesn't matter when it is, they can still settle it. And I have several cases where I filed an offer of compromise, a week ago that might settle a year from now. But what's important is that the person that's been harmed, their pain and suffering doesn't start on the date the lawsuit was filed or the date that the offer of compromise has been filed. That starts right away. And so, what you see in a lot of states, a lot of our neighboring states have the accrual date of the prejudgment interest that relate back to the date that the harm happened, not the date that the lawsuit was filed.
No, I understand, but the interest here, and I agree with the impetus to get parties to come together on an agreement to alleviate the court having to deal with the trial and all of that stuff. But we also have sometimes, when I used to do personal injury stuff, unreasonable plaintiffs also. Plaintiff doesn't, insurance company offers $25,000 on a case before it's filed, and your client says, no, my case is worth 50 based upon what I've seen other cases do. I know you must run into that, right?
Sure.
But in that case that goes to trial, the plaintiff, who arguably was unreasonable during that period of time and was also an impediment to settling, is being rewarded for that period of time. And that's where I'm having trouble with this.
Yeah, I don't see it that way as somebody's being rewarded. When first of all, none of this even really enters the discussion until a lawsuit's filed and an offer of compromise is filed. There are some states that allow prejudgment interest to attach to any result after trial without anyone doing anything. But in our situation, when the plaintiff makes an offer of compromise to settle the case, the insurance company's got the case evaluated. They have an idea of what their reserve is. They know what they're willing to pay. There may be a disagreement about what the case is worth, but if they don't decide at that point to settle the case, then, they run the risk of being wrong. And, why should they benefit in the interim more so than the person that was harmed? It's just one of those situations where, a wrongdoer shouldn't benefit from their wrongful act. And, when you have a situation where, and you reference, you have these cases too, almost always, when there's a case like this and you go to court, the majority of the time, if there's a pretrial or a trial management conference and there's a discussion about settlement, even where there has been an offer of compromise filed, usually the case will resolve at or near the offer of compromise number and even under. But if it doesn't, it's almost never the plaintiff that causes it to happen. It's because the defendant or insurer isn't willing to meet that. And if they're not willing to meet that, then the case should go on its merry way. And if it needs to go to trial and there's a result, then the interest should make the plaintiff whole. It shouldn't be partly whole.
I understand your position. Thank you. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative Fishbein. Comment or question from others, Representative Blumenthal.
Thank you, Mr. Chairman. And I just have one question, so I'll be brief. And thanks, Andy, for being here today. It's great to see you. You mentioned something interesting in the last conversation you had with the ranking member. And I was just wondering if you could kind of expand on it a bit. You talked about how it benefits the insurer to wait or delay settling a case sometimes, and it would not benefit the plaintiff to do so. Could you just describe for us why that would be the case?
Sure. I mean, and I worked for an insurance company for many years when I first got out of school, so I've been on that side. I know how they think, they are evaluated and reviewed based on how much under the value of the case they can resolve the case for. So it's in their interest to hold on to the money and wait and not settle the claims. And it benefits them to do that. And in the meantime, they've set a reserve, they've got the money invested somewhere, and they're profiting from it. Whether it's 1 year, 2 year, 3 years or more, that's just what happens. It's a fact of the matter. Insurance company profits are always extremely high. And, that's how it benefits them. And instead, what happens is the plaintiff is left in a position where most people start a conversation with me when they come in because they've been harmed in some way with, I'm not this kind of person. I wouldn't normally do this, but it seems like often new clients start out that way. And they are, for the most part, just looking for a quick settlement, whatever that means in any given case. And they are often, and there are studies that show, the longer a case lasts, the more beat down a plaintiff gets, and the more willing they will be to settle for a lower number, the longer the litigation goes. I mean, that's just a fact. And anybody that says otherwise is just denying the reality. And that doesn't even get into the situations where insurers take advantage of people. I probably take 2 or 3 calls a month where people have said, yeah, I had an accident. I was injured. I thought I would be okay. I settled for $2,000 3 weeks after the crash, but now I need surgery. Is there anything I can do? I have to give them the bad news that there's nothing that can be done. And that happens all the time. And they know what they're doing when they do it.
Well, thank you for that answer and for your testimony. And thank you, Mr. Chair.
Thank you, Representative Blumenthal. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today. Next, we will hear from Edward McCreary, and I will be turning back over to Representative Staffstrom.
Thank you, co-chairs Winfield and Staffstrom. My name is Ed McCreary. I am the current chair of the litigation section of the Connecticut Bar Association. Quickly we'll add our support to proposed Bill 5237 to streamline the process by which depositions can occur when requested by an out-of-state attorney. And what our Connecticut attorneys are finding is that they're running into obstacles when they go to use other states' versions of the Uniform Act, when they say, well, Connecticut hasn't passed it, why should we let you use ours? It will save our clients money, so we don't have to start proceedings in foreign states because it won't be necessary in Connecticut. And I heard the question asked what states have not passed it. That's Texas, Wyoming, New Hampshire, it's pending in Massachusetts, and it's pending in Montana. Every other state, District of Columbia, Virgin Islands have all adopted the Uniform Act, which 2 Connecticut's representatives to the Uniform Law Commission did support. So we do think it is a little effort to bring our land of steady habits a little forward into the current time frame and jump on board with what the other states are doing. It'll save money all around. And I want to thank Marshall Stevenson for bringing a smile to our faces with their Woody doll collection in the background, because that's, I think, the only thing I found fun to laugh at today in this series of presentations. But that's all I have to say.
Thank you, Mr. McCreary. Questions or comments from the committee? If not, thanks for being with us. Next up is Venus LaBelle, followed by John O'Connor. Venus LaBelle. Okay, then we will go to John O'Connor.
Good afternoon, Senator Winfield, Representative Staffstrom, and all the members of the Judiciary Committee. My name is John O'Connor. I teach in the Sociology Department at Central Connecticut State University. I'm a member of CSU AAUP, and I'm testifying in strong support of SB 163. As a professor at Central, I teach a course on labor unions. Some of the labor attorneys and labor leaders that will appear before you today take some time and come to New Britain and speak to my students, and they all tell the same story. Unions improve the wages and working conditions of workers. Unions oppose favoritism. They seek fairness for workers, and at their best, unions try to democratize the workplace. This committee knows that just 1 in 10 workers belongs to a union. In the private sector, it's 1 in 16. In the past 2 decades, the American workforce has gained close to 14 million workers, but unions lost 2 million members. Yet today, poll after poll shows robust public support for unions, and it is a fact that worker collective action often wins demands. We have all read about the recent Striketober, and still labor's numbers continues to decline. One of the things that I try to communicate to my students is that what unions do and what they can accomplish largely depends on the workers themselves. There are, however, external factors that influence a union success. One of these key external factors is the law. When it comes to workers, our law is broken. The National Labor Relations Act, which was to encourage collective bargaining, has been hijacked by management. The law is now a major mechanism in securing a union-free workplace. SB 163 is an important bill that goes a great way in addressing the asymmetrical power relations between workers and management. Captive audience meetings are vile and shameful. They are a thuggish method by management to pressure and intimidate workers not to join a union. The meetings are a hammer to smack workers and their families. Data show that union certification campaigns are more difficult to win when management holds captive audience meetings. SB 163 allows workers the fundamental right to stop listening to anti-union management propaganda without the fear of being terminated and disciplined. A famous political activist once said in the 1960s that being born in America doesn't make you an American. The same point could be made about our workplaces. Why does management have the right to trash the First Amendment? In these days in which there's authoritarianism all around us, SB 163 moves our state down the path of removing the authoritarianism that exists in our workplaces. Please pass SB 163. Connecticut workers should never be threatened or intimidated. Thank you for taking the time to listen to me.
Thank you. Question from Representative Fishbein.
Yes, thank you, Mr. Chairman. Good afternoon, Mr. O'Connor. Mr. O'Connor, have you ever been employed by someone that employed this tactic?
I have only been employed in the public sector, but I have had students, and students have reported back to me who have actually gone through these meetings, yes.
Okay, and you are aware of the federal law with regard to this area, that what you claim anecdotally may have occurred in someone else's life is already barred by law. You would agree with me?
Well, I mean, the fact of the matter is, it seems to me that what is happening in the use of the law, whether it is on the federal level or the state level, seems to actually just sort of perpetuate the imbalance that exists right within workplaces. And, you know, there's a lot of things that are in federal statutes, a lot of things in state statutes. It's really how this plays out in workplaces that I think a bill like this matters, right? Why SB 163 matters. What the bill is about is just allowing, when these things occur, right, that workers can actually retreat from them and not be punished, right?
Okay,
So in some way, I'm sorry.
So can you give me, when you say these things occur,
those captive meetings.
Okay.
Captive audience meetings.
So can you just give me an example of what you claim this entails?
So I had a student one time who was working, well, I won't say the name of the company, and he actually sort of organized a number of workers to see if there was some interest in forming a union. And what happened is the company got wind of that, and they had a meeting, right, in which the workers were forced to go to this. And they just sort of laid out the sort of doom and gloom scenarios about what would happen if these workers actually organized and then tried to mobilize and collectively bargain, right? They basically said that they would put their jobs in jeopardy, that, you know, unions basically don't help workers, right? That, you know, small leaders, you know, make out, but they'll get nothing out of it. And his argument to me that it was a horrible thing to sort of have to sit through and go through. And that happened in Connecticut.
Okay, and under the National Labor Relations Act, federal law, I expect that you are, as a professor, you are teaching your students that that activity is already illegal for an employer to coerce against association in that form is already illegal. So do you teach your students that?
Well, I talk about the Wagner Act and the National Labor Relations Act, yes. And I also talk about the changes to that over time, right? I mean, the fact of the matter is that, you know, the law very often is fluid and changes and has changed over time. I mean, we know after the National Labor Relations Act in 1935, we know about, you know, what was passed Taft-Hartley in 1947, which in many ways made it more difficult for workers in the United States to organize, right? In some ways, what the National Labor Relations Act gave us in 1935 was taken away in the 1940s, or made it more difficult for workers to organize and mobilize.
So we've had our Attorney General, not the current one, I believe it was the prior one, who has opined that action like this by our state is preempted by federal law, that the feds have already spoken on this. They've already made it illegal. And I'm just trying to see, because what the scenario that you gave me is already illegal. So, and actionable. So I'm trying to figure out why we would need this, because it becomes subjective. You know, if the action is already illegal, when somebody is in the room, let's say, and they're in a group, it's determinative upon them whether or not they have the permission under the statute to leave. The law would have it that they sit through it and that they are a witness to it and that they can bring an action in violation of the federal law. Otherwise, they've left the room and they have no evidence of a violation. I just trying to wrap my arms around why we need this in addition to the federal law. So
I think if we put it sort of in a broader context in terms of, you know, the relationship between management and labor, you know, the feds set a minimum wage, right? But we also know the inadequacy of that federal minimum wage, and we see states trying to rectify, right, the problems associated with that, right, in terms of, you know, the value of that wage and what it buys and what it doesn't. And it seems to me that there are other states across the country that are trying to ensure, right, maybe it is enshrined nationally, right, but there are other states who see the need to try to supplement that federal law and make it real, right? That corporations or businesses, right? I mean, should not be in the business of intimidating workers, right? Or and that workers, you know, should have a right to organize a union.
I do recognize that right. I do support the right of individuals being able to associate. I don't think any employee should be intimidated in the workplace. I'm just trying to look at this legislation, but I thank you, sir, for answering the questions. And thank you, Mr. Chairman.
Thank you. Further questions or comments for Mr. O'Connor? Seeing none, thanks for being with us today.
Thank you.
Stacy Zimmerman's up next.
Good afternoon, Chairman Sastrom, Senator Winfield, rest of the committee. I hope you're doing well this fine afternoon. It's been a long day. So I'm Stacy Zimmerman. I'm here on behalf. Oh, please jump in.
I said this is nothing.
That is true.
Don't curse us, Steve.
I can go very slow. My name is Stacy Zimmerman. I'm with the Service Employees International Union. We've got about 65,000 members here in the state of Connecticut, a couple million nationally. And I'm here to testify in support of SB 163, an act protecting employee freedom of speech and conscience. This strikes a fine line protecting both employee and management's rights to free speech and a safe work environment. Nothing in this bill prevents management from hosting a meeting on any subject, be it work-related or not. It offers some protections from employees from being forced to participate in the meeting that is clearly not about the administration of their jobs. Management, when faced with a workforce that has decided to look towards representation, often use captive audience meetings to skirt the laws to protect the ability of workers to join a union. These meetings are filled with intimidations, threats, coercion. The chilling effect that these have on workers in many cases cause employees to become fearful of standing up for their rights in the workplace. Yesterday's probate organizing hearing in labor is a prime example of that. In essence, what we have are state workers who are too afraid to come testify for their rights because of intimidation in the workforce. Were they direct threats or not? That is unclear, but the fact is it's well known that both the administrator and some judges are opposed to the organizing. So this chilling effect, both in that case and others, not only is apparent in union drives, but many other aspects of the employee's life inside and outside the workplace. They may have to sit through religious presentations. They may have to sit through other political presentations that they don't agree with. They may have to sit through God knows things that have nothing to do with their job that their boss, who is generally a power figure above them, makes them do. So we're saying that this is a nice step and a fine line that gives us all free speech. So we hope you will consider moving this forward. And thank you so much for having the opportunity to testify this afternoon.
Thank you. Further questions or comments? Further questions or comments? If not, thanks for being with us, Stacey.
Thank you.
Next up will be Nancy Marini.
Good morning. Can you hear me?
Can.
Good morning. How are you? Thank you or afternoon, actually. Thank you so much for the opportunity today to testify in opposition to House Bill 5235, which seeks to allow the offer of compromise interest to accrue from the date of the injury occurring or the cause of action occurring. I'm speaking on behalf of Griffin Hospital today. The intent of the offer of compromise statute and allowing 8% interest to accrue is to encourage early, fair, and reasonable settlements. Unfortunately, the impact of the current proposed legislative change would work against those goals. In order to accept an offer of compromise that has been filed, the defendant needs to be able to consider that offer of compromise in good faith. In order to do that, they need basic discovery. They need depositions, they need medical records, they need some basis of the reason that the plaintiff believes that the offer of compromise is a fair and just offer. An offer of compromise can be filed within a year of the filing of the lawsuit. Currently, if it's filed within 18 months, that you would obtain interest that reverts back to the filing of the lawsuit. That is fair. I can argue that it's fair, although I do think it's unfair, because at a year in medical malpractice cases, And in a lot of cases right now, there isn't a lot of discovery that's taken place. If there's a motion to dismiss that has been filed, if there has been a request to revise that's been filed, if there's been a motion to strike that has been filed, within a year, the pleadings are still open. Discovery oftentimes has not been exchanged. And oftentimes, in some cases, plaintiffs aren't even aware of the totality of their damages, yet an offer of compromise will be filed. If a defendant is not able to consider that in good faith, then now they will be penalized with having that offer of compromise interest accrue at the date of the filing. Accrue from the date of the cause of action. I also want to bring to this committee's attention that the date that a cause of action accrues is actually subject of much litigation. It often arises in the case of statute of limitations, because the statute of limitations accrues when an individual has knowledge of a cause of action, right? So especially in medical malpractice, oftentimes that's used as plaintiffs will say, well, I didn't know I had a cause of action that accrued because I didn't have an opinion letter from a good faith a similar healthcare provider to fix my complaint. So therefore, this statute of limitations hasn't accrued. So this language will actually increase the amount of litigation. It will actually increase motion practice. It will increase legal bills. It won't alleviate the dockets, the backlog on the docket, unfortunately. The other reason I want to bring to your attention that, in opposition to this bill is that back in 2005, this committee was part of, an effort to deal with the crisis, the malpractice crisis that was affecting Connecticut. We had a mass exodus of physicians, clinicians, and insurance companies from the state of Connecticut. Our premiums were one of the highest in the state. I think we currently have the 5th highest premiums in the country. But as part of that legislative reform, what this committee did was—
Ms. Marini, we're past the 3 minutes. I'm
sorry. Thank you very much. And I will rely on the testimony I submitted in support. Thank you.
A couple questions for you, I believe. Representative O'Day.
Thank you.
Hi, Attorney Marini. Thank you so much. Thank you, Mr. Chair. And hello, Attorney Marini. How are you?
How are you?
Good, thank you. Just if you could summarize you're finishing up there, any new positions beyond your testimony would be great, or anything that you haven't summarized.
I did want to bring to this committee's attention just the detrimental impact relative to premiums, and not just malpractice premiums, but premiums across the board. I know that when Attorney Savaitis was previously speaking, he was talking about motor vehicle accidents, and that there is unfortunately a large population that does have low limit, lower limits at the minimum. This isn't a way to get around that. If you are seeking to increase people having higher insurance, then that needs to be done. This can't be a way around, because essentially you are going to be increasing premiums, and then all people will have lower, lower coverage. So it does not get you to your end goal, and it's inherently prejudicial to defendants who aren't able to, in good faith, negotiate on an offer of compromise when it's filed. Thank you very much, Representative O'Day.
Thank you very much for your testimony. Thank you, Mr. Chair.
Thank you, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Attorney Marini. Nice to see you.
Good afternoon.
You opened up my eyes to another really bad aspect of this law. I trust you've reviewed the language, right, in preparation for this.
I have, yes.
Okay, so currently we have a claims commissioner's office that's really not doing a great job. And under the present situation, if somebody wanted to bring a claim against the state, they would have to file a claim with the claims commissioner absent a constitutional violation. And in some of those cases, it's taking multiple years for that permission to be granted. So then the lawsuit gets filed. And presently under the system, if I recall correctly, if there's an OC and all of that stuff, and there's claim, you get remedy over that amount, it goes back to the date of filing of the action, correct?
Exactly right. The offer of compromise is filed within 18 months of the filing of the complaint. The offer of compromise interest accrues on the date of the filing of the complaint.
Yeah, but if the case has to go through the claims commissioner's office before it gets filed, and the claims commissioner's office take, let's say, 7 years to dispose of that particular file, then even though the matter can't be resolved, well, I guess it could be resolved under the table between the insurance company, but they're doing discovery and all of that stuff in that process, then you would have interest accrue all the way back for those 7 years, which is significant.
At 8%, right? So it's at 8%. It's extremely, it's penalizing to a defendant, again, who is not in the position of being able to, consider that offer of compromise. Back in 2005, there was, this committee specifically said, if you're going to file an offer of compromise, you have to give a defendant a list of your damages. You have to disclose your experts. You're going to have to also give them an authorization so they can obtain your medical records. And then you can file your offer of compromise. And if you do that, you can avail yourself to the 8% interest going back to the filing of the offer of compromise. That made sense. That made sense because the defendant could then in good faith consider an offer of compromise. In this case, and that was removed, that language was removed in 2011 because, that caused litigation, and just like this will cause litigation, this will cause, not litigation, but it will cause an increase in motion practice. There's no doubt. So, that was removed in 2011. And now we're even going further removed and we're saying, we understand that you're going to have no ability to consider this. We understand that you're not even on notice of a cause of action. You don't even know you're being sued, yet we're going to penalize you at 8% interest. I mean, if it's a slip and fall and someone has fallen on your property, you don't know that they fell on your property. In 2 years, you're now at, that's compounded interest, before you're even on notice of a claim. It's unfortunate. It's really unfortunate. And the damage is, that this will cause is far reaching, and it has a chilling effect, and everything, it is really going to impact the consumer, right? I mean, your healthcare costs are going to go up because this is going to increase the cost relative to malpractice, which increases the cost of healthcare. It's going to increase the cost of your insurance premiums for your homeowners. It's going to increase your insurance premiums for your auto insurance. Municipal liability is going to go up. And this is really far reaching. And I don't understand, the intent behind this change, because it truly flies in the face of the intent of an offer of compromise.
Yeah, I agree. So thank you, Mr. Chairman.
Thank you very much.
Further questions or comments from the committee? Further questions or comments? If not, thanks for being with us.
Thank you very much. Have a good afternoon.
Kurt Ciantar.
Hey, you nailed it. How you doing? Can you hear me all right?
We're good. Go for it.
All right, perfect. Happy Friday, everybody. Good afternoon, Senator Winfield, Representative Staffstrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. I really appreciate this opportunity to give my testimony because I have been held in captive audience meetings. In January of 2020, this is in regards to SB 163, an act protecting employee freedom of speech and conscience. In January of 2020, fellow coworkers and myself tried to form a union at Element Materials Technology in South Windsor, Connecticut. What I believe would have been a fair, empowering democratic process turned quickly into an almost joke of a process where our employer was able to legally obtain a self-described labor relations firm, Littler Mendelson, and hold us in mandatory captive audience meetings. The cornerstone of their attack is based purely on insinuation, planting fear amongst workers, and finally reaping that awful harvest that they call a company win, which is a loss for the employees. This ultimately hurts the working middle class the most. In one of the meetings, we had the pleasure of meeting the executive vice president of aerospace for our company, where he gave us each one of my fellow coworkers and myself a solid 10-second stare without saying a single word before starting the meeting, where he had mentioned that if the company was not profitable enough, we may have to move and close the shop. We had at least 2 meetings a week that were mandatory, where the labor relations firm would present us with hypothetical scenarios that, although possible, were very unlikely. Had a bill like SB 163 been in place, I believe that many of my fellow coworkers would have exercised the right to get up and go back to work and to do what our employer is paying us to do. Not to be forced into sitting these captive audience meetings, hearing conjecture, which has been devised to create an environment of fear and uncertainty amongst our workers and employees. Fear of losing jobs, fear of plant closings, fear of fill in the blank, because as soon as they find out what is fearful for you, they strike at it. They strike you. For far too long, anti-union employers have taken advantage of the legal landscape and defrauded people of fair elections. While workers have the legal right to unionize, employers are allowed to provide inaccurate information regarding unions and workers' rights, create long intimidation campaigns in which workers are forced to listen to consultants who are explicitly paid to prevent them from unionizing during work hours and are not allowed to distribute their own information. They call out any incorrect information that the union busting consultants are providing. They risk retaliation. In essence, the right to unionize is effectively canceled by intimidation tactics deployed by the employers. This is a disgraceful. It's very emotional. I lived it, and I ended up quitting. I resigned from my position as a senior quality technician. I was at that company for 10 years prior to them being bought up by a big multinational corporation, where they forced these kind of audience meetings, and it really, this is 2 years ago, and it's still, I live this every single day.
Thank you, sir, for being with us today and certainly sharing.
And I would like to, not to cut you off, but I would like to, Representative Fishbein, if you have any more questions, feel free to ask me. But I don't think this is preemptive in regards to the NLRA, NLRB. And I believe William Tong wrote testimony for this.
Let's get
similar
to,
language.
Yep, let's get to Representative Fishbein's specific question. Go ahead, Representative.
Yes, thank you. Sir, you said you were subjected to this every day. I'm just trying to figure, did these meetings occur every day?
I don't believe I said every day, and if I did, I misspoke. It was at least twice a week.
Okay. And understanding that under the NLRA, NLRB's rulings, the kind of activity that you've discussed is already illegal. How would this law change that situation?
Well, I don't believe it bars individual states from setting minimum standards for labor for individual employees in the state.
Okay, so what's the minimum bar that this law creates that's different that you would have found remedy under?
Well, it would have given me the ability to stand up and go back to work instead of being manipulated and coerced in these meetings.
Okay. And it's your understanding, well, what you had said is they had talked about possibly moving the plant and that income was down.
No, if profits were down, they insinuated that they may have to close the plant. And it's very ironic and unique that they would bring this up and they'd fly the executive vice president of Aerospace East during a union campaign.
Okay, but in the context of the meeting, they didn't say, if you folks unionize, profits will be down and we may have to move.
No.
Okay. So it's your understanding under this law that if an employer got their employees together and said, we're not making quotas, income's down, perhaps, we just went through a pandemic, pandemic is negatively impacting us, may have to move, that you could walk out of that meeting?
I don't disagree with talking about company policies, how well the company is doing profitability wise, but during those meetings, and this is 2 years ago, I'm reliving this today, we certainly talked about consequences of the union and how that could relate to decreasing profits and how we may have to move work elsewhere.
Well, I thought I asked you that question, and I asked you if they talked about if you unionize, there's a negative impact on the business, may have to move. You said they didn't mention the union portion of that. They just talked about the fiscal health of the company, that they might have to move. And you insinuated or you had the impression because
Do you
that was
disagree
during,
with SB 163, sir?
I didn't hear the question, sir.
Do you disagree with Bill SB 163?
I do. It's preempted by
Okay.
federal law. Yeah.
So it's
I'm
preemptive.
just-
You believe it's preemptive?
I know that it's preempted.
Gentlemen, let me interject here. We're not debating the legislation right now. This is a public hearing.
Yes, that's fair.
If the representative has unique questions that have not been asked and he would like to ask them of this witness, let's do so, and the witness will answer them.
Yeah, I was just trying to get the context, and I think I understand the context. So thank you, Mr. Chairman.
Thank you. Further questions? Further questions or comments? If not, we'll move on. Next up will be Charles Borchert. Charles Borchert. How about Roberto Fernandez? Roberto Fernandez. Let's see. Hold on here. Okay. Oh, no, maybe not.
Can you hear me now?
There we go. Go ahead.
Sorry
sir.
about that. How are you? Good afternoon. My name is Roberto Fernandez. I'm the political director for 32BJ SEIU. I was here to read the testimony and present with Mrs. Emma Vasquez, who unfortunately, whose child got ill this afternoon and is currently at the doctor's office. But without any objection, I would like to read her testimony.
Yeah, I mean, if it's already written and in there,
Submitted. Yep.
It's not really, I mean, if you'd like to summarize it briefly, but if it's already
Sure.
submitted,
Sure.
we've got
Basically,
her testimony.
right. And basically what we're testifying for is the rest of a lot of the service workers that we represent, which we represent, food service workers, cleaners, security officers, have been and continue to be at times when the purpose of unionization comes up, forced to be into captive audiences. And what Ms. Vasquez was talking about was her experience during our ability to bring up the unionization efforts on our service plazas to these vital workers, and how management continued to, and to this day continues to, disparage the union, telling them that the union is not good, telling them that the union doesn't do anything for them, and that they would just be wasting their money. I'm really sorry that she was available this morning in the press conference, so her testimony and her her testimony as to her experiences will be reflected in the press releases this afternoon. And I'm just hoping that once and for all, we can eliminate this. And please support Senate Bill 163. And I'd be happy to answer any questions if I can.
Well, thank you. And certainly thank you for highlighting her testimony for us and giving voice to that. Questions or comments from the committee? If not, appreciate being with us. Next up will be Jasmine Vendretti. Jasmine Vendretti. Okay, I think got a hand raised here. Let's see. All right, Ms. Vendretti, can we see or hear you? Ms. Vendretti, if you could unmute yourself. Yep, there you go. We got you, I think.
Good afternoon, Senator Winfield, Senator Strasform, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Jasmine Vendredi. I am a union organizer with AFT Connecticut. I am here to testify in support of SB 163, an act protecting employee freedom of speech and conscience. For over 9 years now, I have worked mostly in external organizing, helping workers in the private sector for forming their union. The the law dictates a simple process where workers employed in the private sector to form their union. It's simple as checking yes on the box in a ballot provided by the National Labor Relations Board. Of course, there is this whole process of, an organizing campaign. The federal agency that manages union elections show up to workplaces to organize elections. However, the attacks employers mount against workers during that process make us believe it's not simple. During this past 10 years in the labor movement, I have witnessed how detrimental these attacks have been on workers and their unions. Employers, instead of following the rules, use their position of power, sometimes by contracting specialized union busting firms to show up to the workplace to intimidate workers. They do that with the intent to dissuade workers from forming their union. Workers are threatened, intimidated, submitted to surveillance as if they were not free individuals. In 2018, I helped organize the bargaining unit of service and maintenance workers at a hospital here in the state of Connecticut. Members of that unit experienced it all. Employer mounted an anti-union campaign. Here is what one of the members of the bargaining committee told me about her experience. I was called into my boss's office and spoken to about the union. I was very uncomfortable. What I remember most about my conversation with that worker was how shaken her voice was. From there, things changed for her. We are talking about a single mother whose livelihood depends on that job to take care of her daughter. Tamika Gilhooly didn't deserve that experience. During that same campaign, on multiple occasions, workers were called into meetings with representatives of HR during work hours. On top of this misinformation campaign put together by management, they distributed lines of lies about AFT Connecticut and the other locals. The company also sent multiple mails to workers' home, multiple emails to the workers' work emails, as well as some of their personal emails. There were some workers disciplined unjustly, some were targeted and were submitted to surprised drug tests. The employer also promised these workers benefits they have lost years prior.
Jasmine, your time has elapsed. If you could summarize.
Thank you for holding this public hearing to allow workers to share their stories. I urge the committee to protect workers' constitutional rights by passing SB 163. Thank you for the opportunity to testify.
Thank you. Representative Fishbach.
Hi, Jasmine. How are you doing this afternoon?
Good.
So I just, in listening to what you had to share with us, were you talking from personal experience or are you talking about somebody else's experience?
So as a union organizer, it's also my personal experience because, I am hired and I've spent a lot of time exchanging with those workers. So somehow the trauma they experience during, the organizing campaign, you get as an organizer to hear those stories too and kind of like have to process them as an individual. So to your question, Senator, I would say yes. It's also from personal experience because.
So what's your personal experience with regard to, because somebody tells you something and then you share it with us, that's not your personal experience. So what has been, your personal experience?
I do see your point, but my personal experience when I am working on the union organizing campaign, having to, put everything organizers can think of to be successful in a campaign, and then the members of the union, right, those prospective members of the union get to experience that trauma in the room. Of course, it's my own experience too as an organizer because we don't particularly separate ourselves from the experience of the workers. But I do get your point that as an organizer, meaning a staff person from a union, I am not in the room myself.
Okay, but you're like you're part of the umbrella that covers all of these unionized individuals. Is that fair to
Let's
say?
put it this way, these workers are trying to join the union I work for. So yes.
Okay. And you specifically said that these individuals received mailings and emails saying, you know, don't join the union, unions are bad, this kind of stuff, right?
Yes.
Okay.
Yes. I've actually personally started like a mini library of anti-union rhetoric from different employers in Connecticut and beyond.
And when you, as a representative of AFT, filed your federal lawsuit against that employer, what was the result of that case?
So in one particular campaign I worked, not the last one, so the problem is that it takes a long time for the federal government to litigate a case regarding retaliation during organizing campaigns. Fortunately, the campaigns I've worked on, knock on the woods, they've all been successful campaigns where, you know, the union vote prevails. But there have been cases where the workers are being disciplined or fired, but then by the end of the campaign, that worker literally had experienced this adversity. Yes, in my case, I've been lucky enough, you know, those workers have been lucky enough, organized well enough to win the election, but it could have gone a different way because the impact of that termination on the entire campaign could be detrimental to the campaign itself.
Okay, so my specific question had to do with, you claimed that emails and mailings were sent to these individuals telling them, do not unionize.
Yes.
That's what you said.
And
you wouldn't need anything else. You would attach that to a complaint and you would file that with the federal government. And my question was, when that was done by AFT in representation of these individuals, what was the result of that case?
For that particular case, like I said, from that campaign I worked on, for example, at CHS, the worker was able to regain her position. Actually, she ended up not going back to work and to that place, but took a settlement. So I guess I've answered your question, Senator.
No, but you spoke in the plural. You said that mailings and emails were sent to these employees. And now you're talking about one particular individual. I'm just trying to figure out.
So for all the campaigns I've worked on, yes, there have been emails and mails sent. Yes.
Okay. And was there a complaint made to the federal government under the current law?
Yes.
Okay.
Yes,
Well,
you have.
And I've asked you like a few times, what was the result of that complaint?
So in one of the cases, so what happened during the organizing campaign, of course, you file your ULPs, and then after the election, sometimes the union withdraw the cases. For some of the campaigns I've worked on, that was the case because we won the campaign, and you just get to go to the bargaining table. The need to actually continue to litigate that specific case, it didn't matter anymore. Because you already won and you can continue the fight at the bargaining table. But in that other instance, like I explained to you, for that worker, her name is Digny Baker from CHS in Hartford. She was retaliated against, and yes, all of those documentations were attached to the file for her case.
Okay, so that was utilization of the law as it presently exists, right? So I'm just trying to figure out, if this statute passed, the language that's before us, how would that change the situation? You'd still be able to complain to the federal government.
Yes,
right?
definitely. What I would say though, the laws that we have right now, they are not good enough. Actually, I urge the representatives of the state of Connecticut to actually find a way to make them better. There are ways to make them better. And
Well, I'm talking about this specific statute.
Yeah, so
How would this change it?
so SB 163 could just, I guess, give workers the possibility to feel free for a moment, right? This possibility of being able to get up from a meeting where you are being intimidated. It's something they don't have right now, and that's the most important part of this bill. I think we should keep in mind. You can think about a single mom. You can think about a brand new immigrant or a person of color finding themselves in rooms with people with authority and power, where they are literally doing something that the law recognizes as a right that they have, but then are being submitted to such treatment. And I don't think any of the representative of the state of Connecticut would stand for something like that. And that's what this law is trying to do.
So assuming that's the case, so somebody is in a meeting with their employer and their employer says something like unions are bad, right? I don't want you unionized. It's going to be a negative impact on my business, something like that, right? You would give the employee the right to walk out of the meeting, right? That's what this law would do, right?
Yes, the right would do that. That's when it comes to, let's say union organizing, but we can go beyond that. Let's say you work at
we can't go beyond that because that's all this has to do with.
No, the law, it's a freedom of, if I read it properly, it's protecting employee freedom of speech and conscience. So we are talking specific. In my case, as a union organizer, I testify to the experience with using the experience of union organizing and the experience of workers during organizing campaigns. But you can think, for example, of somebody who is, anti-abortion, and then they work for an employer who is pro-abortion, and they are being scolded in a room where they are told to support abortion. So it's also about that. It's also, there is this aspect of the bill I think could be useful to us as a society.
Okay, just coming back to the union aspect of this. Right now, why can't the employee walk out of that meeting?
Because it's a mandatory meeting. Those meetings happen during work hours. And
Understood. But if the employee walks out of that meeting and files a federal lawsuit, or they are, let's say they're fired, their defense is that the employer was violating the federal law under the present law, right?
From a legal perspective, definitely. But why enabling, I would say, employers that power, right? And from a worker's perspective, you don't want to do that. Yes, the law exists, but if we were to look at the fact that the law exists to take a stand, we would be in a very bad place, as a society. Of course, I can understand your position on this issue, but it's not the positions of working people. It's not the positions of workers, of those people who actually experience that terror from their employers.
No, I understand. And I'm just trying to figure out why this is necessary as opposed to what we presently have. And at least in my mind, we haven't gotten there. But anyway, thank you. Thank you for the exchange. And I didn't know if you wanted to say anything else.
I only wanted to say that I don't wish for you. Maybe it's not something that's that's possible at all, but I don't wish for you or anybody to experience that. It's you haven't done anything wrong. You're being locked in a room, for example, to listen to things you don't necessarily agree with, but you have to because somebody have some sort of power over you. And I guess if there was something for me to add, it's nobody, no worker ever is supposed to be submitted to such treatment.
I will offer, though, that locking someone in a room and subjecting them to a message that they're not comfortable with, and terrorizing them is already illegal under our criminal code. I believe it's unlawful restraint, but anyway, we go on. So thank you, Mr. Chairman.
Thank you, Representative Fishman. Representative Porter.
Thank you, Mr. Chair, and thank you, Jasmine, for your testimony today. I tell you, lived experience is key in all issues. And, you know, I say it all the time, the people closest to the problems are closest to the solutions. And what you are expressing, and many others that have come before you, that coincidentally look like you, right? I think that's something we need to talk about too, and something that was actually said by some of the people that came before us to support Senate Bill 163. This is a form of intimidation, and you've spoken about retaliation. So let me ask you, what does some of the retaliation look like? Can you describe to us? I mean, because I know it's been described, but I think that we do need to belabor this issue.
Anything you can think of, actually. Some workers are being fired, you know, when they challenge those type of meetings. Some workers are disciplined, and discipline can take various forms. Some managers go even using personal information they have about workers sometimes to target them, right? They know, for example, they have to leave work at 3 to pick up their kids at 3:30 from school. They change their schedule. And then now you have, you know, sometimes working class people having to juggle between finding someone to pick up their kids. It goes on and on. Anything you can think of that can literally disturb the life of someone who is at a workplace. Anything can happen during an organizing campaign, and captive audience meetings are just a little part of it.
Can you just speak to, you know, what are the outcomes? You know, like I'm listening to these stories, and I'm remembering one in particular that came before you, how she was held 3 hours in a meeting where she told it would just be a few minutes, and, you know, continued to have to hear about why this would be a bad idea and bad for workers if the union came, blah, blah, blah. But let's talk about the impact on the employee, because we're dealing with a pandemic where even people who are strong-willed and strong-minded are really struggling mentally to get through this pandemic. So now on top of that, we have people that are stressing because they don't want to lose their jobs. It is coercive control.
Mm-hmm.
You have the power to do this. You do this, and I deal with it. But what does dealing with it look like as a worker who's been subjected to captive audience?
Dealing with it can mean anything. It can mean having to find yourself a different job, because, you know, some people, you know, make the decision to not even be at those places anymore. And why would, you know, someone have to do that? What have to do leave a job because of something like that? So sometimes, and even most of the time, people that get the cold shoulder from management, or they, you know, things that happen normally becomes a problem. You know, if you are gonna be late 1 minute or 2 minutes, all of a sudden it becomes a big issue, and you are being, you know, there's a big file about you, and you are being intimidated, and you're being surveilled. You're worried about who you talk to, what you tell your coworker. You are scared. Anything you can think of. So during an organizing campaign, of course, as organizers, we explain to workers, to members of the union, that to expect all of those. We do what we call inoculation, but why is it even something that employers are engaging to? If we that it's
I agree. And, you know, the good representative is right. We do have laws on the books, but we also know that, you know, we have a lot of laws on the books that are not being enforced. And sometimes you have to come back and you have to tweak things and make it tighter and hold people more accountable, because it is so egregious what's going on. So I thank you for having the courage to be here today. I thank you for the grace in which you have answered questions as you have been literally questioned. I'll leave it at that. But just thank you for the way that you've handled yourself, and thank you for the work that you do. I know the importance of organizing. I know the importance of strong unions. It was a time which made this country one of the largest expanding middle class societies. So I think that is what we're really trying to bring back. And we're really trying to do it in a way that helps everyone, employers and employees alike. And I think when you have happy workers, you can't help but be happy if you're the employer. It's a win-win for everybody. And it is our job to make sure that the working class people in this state are able to do so with dignity and respect. So thank you again. Have a great day. And thank you, Mr. Chair.
And I actually, this morning I was reflecting on this whole thing. I told myself that at some point when we have organizing campaigns, when we think about all those things that workers experience, we probably should start thinking about having mental health available
Absolutely.
to workers during campaigns, because it's just not sustainable to experience.
Absolutely. And I thank you for making mention of that. And thank you, Mr. Chair. I appreciate the time.
Thank you, Representative Porter. Comment or question from other members of the committee? Comment or question? Seeing none. Jasmine, thank you very much for joining us this afternoon. Have a great day. Next, we have Jacqueline Conlon, followed by Johanna Alibi and Stephen Julian. Jacqueline Conlon.
Yes, sir. Good afternoon, Senator Winfield, Representative Fishbein, Senator Kissel, and Representative Staffstrom. My name is Jacqueline Conlon, and I'm an attorney. I practice family law, and I've been practicing since 1993. I'm here to testify in opposition to House Bill 5268, an act concerning the award of reasonable attorney's fees to the prevailing party in a family relations matter alleging contempt of a court order. That's a long title. This bill would likely have a chilling effect on people bringing valid claims of contempt to the court and would impair the court's ability to enforce court orders. Further, if a person cures the contempt on the courthouse steps, which happens quite frequently, no attorney's fees would be allowed to be granted by the court. We also believe that taking away the court's discretion in a motion for contempt is something that isn't good for the public. The court, the judge, has the ability to see the people, hear the stories, and be able to order them if the need should rise. I suspect that the reason that this bill was put into place is because there's been issues with access to justice for families in the state of Connecticut. The judicial branch has put in place a system called Pathways. It replaced an imperfect system that we had in the past, but you could move cases in that imperfect system. Currently, with the Pathways system that's been in place since last January 1st of 2021, we find ourselves not able to move cases for clients. There's a lack of accountability on the branch to respond to clients and individual needs, and there's a lack of transparency for the system. I'm thanking the committee for allowing me to speak, and am happy to answer any questions anybody might have.
Thank you for your testimony, Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Jackie. Nice to see you.
Good afternoon, Representative Fishbein.
Jackie, I think your suspicion is correct. A lot of frustration out there, and just that I can understand a little bit more from your practice pre this Pathways situation. Let's say you filed a divorce, you filed a motion for child support, you got a mom with 4 kids, dad's left the home, let's say living with his significant other, whatever. How long would it take you to get into court pre-Pathways?
2 to 4 weeks. And only 4 weeks in Stamford because they have a longer time period to try to get people to settle.
And then that 4 weeks, you would more than likely have a hearing before a judge, you'd get an order, and mom would be able to get child support. Is that fair to say?
Yes, sir.
And now with this Pathways program, same scenario, you filed an action tomorrow, that motion, 4 kids, all of that same stuff. How long is it going to take you to get an order for that mom?
I wish I could tell you, Representative.
Is it?
We don't know. The way the new system is set up to work is the divorce is filed, you file the motions for alimony and child support, or even custody of children, and you essentially wait anywhere from 3 to 6 months before you get something called a resolution plan date. That resolution plan date is a meeting of the parties with family relations to see if they can settle the case, and also to see if, to put it on a track. There's tracks A, B, and C, A being the least amount of court intervention and C being the most. So we were told that we could file requests, case flow requests, and if it's a motion that needs to be heard more quickly than that. Well, no, my firm, other firms throughout the state, this is a problem that we've all been talking about and trying to figure out how to solve. You file the case flow requests, and as one colleague has said, they go into the ether. You don't get the dates to get into court. I think it makes it's kind of weaponized the system, because there are some people who just don't want to pay, and there's some people who just don't want to co-parent their children. And if you can't get people to agree, there's no place for us to go to have somebody in a black road decide the issues.
And let's just say that while the case is pending, that there's some sort of an altercation in front of the kids. It doesn't rise to the level of a 46B15 restraining order or DCF intervention or police, but it's exclusive use sort of situation. You file that motion for really the betterment of the total family unit. How long is it taking to get into court on those? Well,
Unless you file an emergency motion, and an emergency, the way I was taught, it has to be a real emergency. It's not something that you just want to get into court fast on, and you don't want to take advantage of the court system. Unless you file an emergency motion, it's the same length of time. You don't know when you're going to get a motion for exclusive possession heard. We have a case here where dad moved out. There was a criminal protective order. Mom agreed to modify it, and dad now says he's moving back in. And it's not an emergency motion, but it's going to be awful for those children living in the home.
And I believe we've had testimony recently, or at least a report, where the amount of emergency motions has dramatically increased during the pandemic. Has that been your experience as well?
Absolutely.
And what do you attribute that to?
I attribute that to people not being able to get into court. We all know that the pandemic caused, it disrupted everything, and the court has a backlog. But the way that people now are trying to get court time is by filing emergency motions for things that aren't necessarily emergencies.
Yeah, that's been my experience as well. And I, I'm going to be done very shortly, but, in the old days, an emergency was an emergency. Now everything's an emergency, which dilutes the actual emergencies in my experience. So thank you, Jackie, and thank you for coming before us here today.
Thank you, Representative Fishbein.
Thank you. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us today.
Thank you.
Next, we have Johanna Alabi, Stephen Julian, and Phyllis Frazier. Is Johanna in?
Hi. Can you hear me? Hi.
Are you Stephen Julian?
No, I'm Joanna Labby.
Oh, because it says Stephen Julian on. Okay.
Yeah, because we're on the same.
Oh, okay. All right. Proceed.
Good afternoon, Senator Winfield and Representative Stratford, and the member of the Judicial Committee. My name is Joanna Labby, and I'm a certified nursing assistant at the Hebrew Home in West Hartford. I'm here today to give a testimonial of support to the SB 163. This bill protects employees and their rights to exercise their freedom of speech and join a union, and it prohibits employers for coercing employees to attend and participate in meetings for purposes of forcing the employer's position, politics, religion, or labor organization activities. I'm here today to tell you about my experience. Several years ago, my coworker and I decided that we wanted to form the union so that we could have a voice in our workplace. In response to this, Hebrew Home brought in strangers from out of state counseling agency, Jackson Lewis, to harass and intimidate me and my coworker. They bombarded us with verbal, threatening text messages, the contents of which is too disgusting to read aloud. They forced us to attend anti-union meeting when we could have been taking care of our patient, and posted private information of staff openly discuss on unionization. In this first meeting, they show anti-union videos telling us not to vote to join the union, and threaten if we do, we will be terminated. There were blunt racism in their tactics, using by the counselor, who were all white men. They told us the Jamaican community was ashamed of us. They told us we were not to speak our native language, and pushed for us to sign an agreement that we cannot speak our language in the workplace. One morning in the dining room, the assistant director of nursing pulled me aside and told me she know that I'm trying to get my coworkers to unionize, and threatened to terminate me. I did not stop my effort. Hebrew Home promotes division among staff by protecting and rewarding anti-union behavior. One day, a coworker who was anti-union physically assaulted another coworker who was trying to get another to sign the petition to unionize. Instead of punishing them for kicking their coworker, Hebrew Home gave them a promotion.
Johanna?
Yes.
Your time has expired, so if you could summarize.
Okay, so all I'm asking you, please, we need SB 163. We need, we need our voice to be heard. We need to, we need protection, and this bill will help us. Thank you.
Thank you. Are there comments or questions from members of the committee? Representative Porter.
Thank you, Senator Winfield. And hey, little Gary. Thank you for your testimony. Just a couple of questions. You said in your testimony that they posted private information. Could you tell me a little bit more? I'm just wondering, like, where did they post it, and what kind of information was it?
Okay, so they have a train of text messaging, and they have names, address, phone number that they put in text, and they send it out to everybody, and stating that, oh, this person is no good, what they're doing is wrong. They're, and at some instant they said that this person's tire was cut, and it was cut by this person who is organizing the union. So they basically have all our information out there, where we live, what we do, the time time of day that we come to work. So we were just out there. So if anybody wanted to hurt us, they know exactly where to come. My address was one of the address that was displayed in these text messages. So everybody know where I live.
Yeah, which creates a culture of fear. I mean, I can't imagine living under that kind of duress. I'm also curious to know, are you still with this employer or have you since left? I mean, what was the outcome?
I'm still there. I'm not running.
I know that's
you know, we organized a union. We got the union. It was 109 to 35. We went strongly and we're pushing and I'm not leaving.
All right. Well, thank you. Those were the two questions that I really wanted to get answered before we let you go. But thank you again for the courage to come and testify, to tell your truth and your lived experience, and to lend voice to the other workers who may not have gotten the courage yet, but I hope that they will, because we need to hear from the folks on the ground.
And
so
one
thank
more
you.
thing, one more
Yes.
thing, Stefan Giuliani cannot be here today, but her testimony is here and we have somebody who would like to read it if that's okay.
Well, you have to ask the chair that, but
sorry.
Yeah, I'm just a member of the committee.
Okay.
And also the chair of labor. So this is near and dear to my heart as well. But
Okay.
thank you again and have a great day. And thank you, Mr. Chair, for the time.
Thank you.
Representative Porter, is the person you're speaking about the individual who is currently on screen as Stephen Julian?
Yes.
All right, Stephen Julian's up next. I'll ask a couple of questions and we'll see how that proceeds. Are there comments or questions from other members of the committee? Comments or questions? All right, if not, thank you very much for joining us and sharing your story with us today.
Thank you.
Next up, I'm on a camera. Next up, we have Stephen Julian. And I see that you're on the camera. And what is your name?
Hi, can you guys hear me? Because I'm at a totally different computer.
We can.
So my name is Kim Piper. I'm actually the vice president for 1199.
Okay.
And are you okay with me continuing to read her testimony?
Well, let me ask you a question. Did Stephen actually submit that testimony to us? Do you know?
I believe so, Senator Wilfield. I can definitely double confirm, but I believe so.
If she did, what I would like you to do is give us the highlights of her testimony, if we already have it. If you could do that.
Yeah, it's actually a shorter one, so I can read it.
Okay. All right,
yeah, it's actually a shorter one. So of course, in support of SB 163, in 2019, my coworkers and I decided that we wanted to form a union. To fight us, our employer hired union busting consultants, Jackson Lewis. There were some captive audience meetings, folks being yelled at, being intimidated. One example she provided is that if I complained, I was ignored. If I tried to have an opinion, I would be suspended or taken off the floor. They got West Hartford Police Department to intimidate us. The police were parked outside the building in the morning when we got to work, and they were there when we left. So it was a sense of intimidation and chilling effect for the workers here. And in ending it, wanted to support SB 163.
Thank you. What was your name again? I'm sorry.
So I'm actually Kim Piper. I'm the lead organizer for this particular campaign. So I know very intimately well what took place. So when it comes to those text messages, it was actually my cell phone number that was stolen and used to intimidate the workforce here.
I'm sure you do, Ms. Piper. I am appreciative of you for being here on behalf of Stephen Julian, and let us see if there are comments or questions. Other members. I don't see any, but we're appreciative of you and actually of all the members, and I'm so trying to keep my kids quiet.
That's all right. We're a union of families, so we understand.
They don't care what we're doing. Thank you very much for joining us today.
All right. Thank you, guys. Have a wonderful day.
We next hear from Phyllis Frazier, followed by Antoinette Osei Bonsu, and then John Blair. Phyllis Frazier, are you there? Phyllis Frazier. Okay, if not, Antoinette Osei Bonsu.
Hi, good afternoon.
Good afternoon, you may proceed.
Okay. Hi, my name is Antoinette Osei Bonsu, and I'm in support of SB 163 and Act concerning employee freedom of speech and conscience. So good afternoon again, Senator Winfield, Representative Stanstrom, and members of the committee. My name again is Antoinette Osei Bonsu, and I am currently a member organizer with District 1199. Before I joined 1199, I helped lead the organizing drive at my nursing home, Kettlebrook Care Center, LLC. I'm here today to ask you to support Senate Bill 163 and to tell you about my experience as a worker trying to organize a union in my workplace. When we organized our union, we had to deal with harassments from the bosses, captive audience meetings, racial discrimination, and separation, constant intimidation, and my own sister, who was a leader in the fight, was terminated at one point for absolutely nothing. Throughout the entire campaign, we filed at least 40 unfair labor practice charges against the facility. I filed my own for harassment because it got so bad. At one point, we met in the Walmart parking lot away from the facility to talk about the organizing drive. The facility called Walmart to try to stop our meeting. They chained the doors on our building so we couldn't march in on the bus. As a result, workers on the first shift couldn't get out of the building due to the chain doors. They tried to tear us apart. Excuse me. So what they did is they tried to tear us apart by giving the white workers. So at one point, so they tried to tear us apart racially too. The company convinced white workers to desert because of racial discrimination. Meanwhile, the bosses were giving white workers raises and sending them back to school for job promotion, while Black and brown workers got nothing. It was so stressful and scary, but we got through it together and won our union. My sister even got her job back too. SB 163 gives employees the right to organize without fear of facing discipline or termination. Employers should be held accountable for the tactics that they utilize when workers want to equalize the playing field. They play dirty. Senate Bill 163 will protect workers' rights in Connecticut. It is important that you pass it. Thank you for your time.
Thank you very much for your testimony. Comment or question for members of the committee, Representative Porter.
Thank you, Mr. Chair. No questions. I just wanted to thank you, Antoinette, for coming out. I'm glad that you persevered. I'm also very happy to hear that your sister got her job back. And just thank you for being an example and for leading by example.
All right. Thank you so much.
You're welcome. Thank you, Mr. Chair.
Thank you, Representative. Comment or question from other members of the committee? If not, Antoinette, thank you very much for joining us. Unfortunately, as we've heard this bill over the years, there are some themes that seem to persist, and they speak about issues even broader than the issue that we're specifically talking about today. Thank you very much. Next, we have John Blair, followed by Dan Livingston, followed by John Brady. Is John Blair in? I see. You may testify.
Thank you. Good afternoon, chairs, ranking members, and members of the Judiciary Committee. My name is John Blair. I'm Associate Counsel at CBIA. To no surprise, CBIA opposes Senate Bill 163, this year's version of the captive audience bill, as it attempts to suppress critical workplace communications. This is a measure that CBI has consistently opposed this measure year after year. The first issue I'm going to speak to is preemption. The language in Senate Bill 163 directly mirrors that of bills from previous years' intent, form, and substance, all of which failed primarily because they are preempted by federal law. The NLRB remains the exclusive authority over employer-employee workplace interactions. SB 163 includes a definition of political matters. In the definition, it includes the terms legislation and regulation, which makes it overly broad. I want to now speak to a couple of the benefits to open communication between employers and employees. There are many benefits of allowing employers and employees to openly discuss matters that affect each other. Our members are concerned how this proposal greatly restricts their ability to communicate critical workplace matters with their employees. If this proposal was law during the pandemic, it would have restricted employers from communicating on a wide array of employment-related executive orders, laws, regulations associated with the government's management of the public health crisis. Employers would have been prohibited from updating employees regarding mask mandates, vaccines, flex schedules, hours, wages, to name a few. Additionally, if this proposal becomes law, employers will be precluded from holding critical workplace meetings or having honest conversations with employees without the risk of people walking out. Employers would not be able to update employees regarding laws and regulations impacting their jobs, wages, benefits, FMLA, corporate and community charitable giving, and social activities. The fact that this measure keeps surfacing year after year is concerning enough. That has been resurrected again at a time when employers, particularly small businesses, are struggling with the labor shortage crisis, inflation, supply chain bottlenecks, and COVID is just too much. The proposed bill ultimately places a gag order on employers, leaving employees in the dark on matters that directly affect them. It not only dictates how employers interact with their employees, it reflects an adversarial attitude towards Connecticut businesses. We urge lawmakers to vote Senate Bill 163 down. I'd be happy to answer any questions.
Thank you. Comment or question from members of the committee? Representative Fishbein, your hand was up and down. I'm not sure if you had a comment. I'm not sure.
Yes, sir. I was just, I was being a buffer in case Mr. Blair was unable to get his points out. So I dutifully took it down when I did not find it to be necessary.
Got it.
Thank you.
It's clear to me now. Got it. Comment or question from members of the committee? Comment or question? If not, thank you, Mr. Blair, for joining us this afternoon. Enjoy the rest of your day.
Thank you for giving me an opportunity to speak.
Next up, we have Dan Livingston, followed by John Brady, followed by Barry Hawkins. Dan Livingston, I see you. You may testify.
Thank you, Mr. Chairman, Representative Staffstrom, members of the committee. My name is Dan Livingston, and I'm proud to be an attorney representing unions, civil rights, and other progressive organizations for almost 4 decades. I've submitted written testimony and a legal memo, and both in support of Senate Bill 163, so I'll keep my verbal testimony brief. Outside the workplace, we vigorously defend the rights of people to decide what political, social, or religious material they read, watch, or hear. You can watch MSNBC or switch to Fox News. You can listen to Biden's State of the Union, or you can turn it off. And the same can be said of the Republican response or the response of any other political group, from Nazis to anarchists. Listen if you like, attend if you like, but no one can say you have to. Listen to religious instructions from a priest, a pastor, a rabbi, an imam, or a denunciation of religion from the most stringent atheist, or don't. Listen to the most passionately anti-union or pro-union speeches you can possibly imagine, or don't listen. This right to avoid being a captive audience is of a political, religious, or social speaker that you don't want to hear is fundamental to our freedom. The question that is raised by Senate Bill 163 is why Connecticut law takes away that right because people have to work for a living. The memo I've attached makes clear, and I'm sure other more eloquent writers have made clear, it is indeed our current state law that deprives us of that right, not legislation, federal or state. And the General Assembly has never taken that fundamentally undemocratic position. It is Old English common law, master-servant law, which remains the law of this state about forced meetings inside the workplace, centuries-old notion that an employer owns you during your work hours and may direct you to do whatever the master wants, no matter how unrelated to your work, including being compelled to listen to political, social, or religious views that are complete anathema and have nothing to do with the workplace. That's the state law, master-servant law, 400 years ago. No General Assembly has ever passed, but we uphold it every year when we don't pass bills like Senate Bill 163. And don't buy the notion that this is only about the employers fighting unions. I have on my screen now, I won't take the time to share, a Facebook page of a congressional candidate speaking to a captive audience of hundreds of U-Haul workers in Phoenix who were forced back to headquarters and required to listen to his speech by their supervisors. This is part of a national effort by many large companies to use their power to impose their political views on their workers. Again, without Senate Bill 163, Connecticut master servant law makes that legal. It's very difficult to get employees who've been subject to this kind of treatment, who don't have unions or unions to protect them, to come to the General Assembly to testify. But this committee needs to be their voice. I ask you now not to, by inaction, effectively adopt a 400-year-old doctrine that our society should long ago have passed, and to please vote for Senate Bill 163. I'd be happy to answer any questions.
Thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Dan. Nice to see you again.
You too.
Dan, I just want to ask you the width and breadth of the employer-employee relationship. You make it, well, I think you said that an employer can demand of an employee to do anything when they're on the clock. Is that your position?
Master servant law basically makes the employee's actions owned and controlled by the master during work time. We have passed over the years. I like the way I say we, like I was actually in General Assembly, but the General Assembly and Congress have passed a number of laws over the years that restrict that power based on certain number of different classifications of things. But one of the powers that continues to persist is the power to force employees to listen to the political, religious, or social views of the employer, regardless of whether they have anything to do with work. That's old master servant law. General Assembly has had lots of opportunities to change it, but hasn't done it yet. And I hope this is the time.
So you are of the position that an employer is permitted under the law to force an employee to listen to a speech denigrating unionization and that type of association?
State law allows the employer to take
under any law.
I'm trying to answer your question, Representative. So state law allows that by providing the employer the power to compel you to be in the location, and there is no federal or state law which prohibits the employer from forcing you to listen to his or her opinion on the union, on religious matters or political matters.
Well, no, well, please correct me if I'm wrong, but I thought it's expressly prohibited under the NLRA for an employer to coercively position the employee against organizing a labor union.
Well, I'm not sure exactly what that sentence means, Representative. I'm sorry, but the National Labor Relations Act does prohibit certain employee conduct based upon a motive and coercion. However, it does not prohibit an employer from firing an employee for insubordination. So if I use the power that the state of Connecticut has granted me as an employer to say, you must come into this room and listen to this speech, and then I refuse, and you say that's a directive, I'm the employer, I'm the boss, I get to say do this or else, and you refuse, then the employee is fired for insubordination, and discharge for insubordination is not prohibited by the National Labor Relations Act.
However, if the individual ascertains that because the scenario that I presented you with was the discussion, the speech, right? Not the firing, right? I believe the NLRA restricts the employer from that conduct presently. And
no, that's absolutely correct. An employer, and I think that's some of the confusion about some of the prior testimony. I heard the CBIA's testimony, and I heard some of your questioning of prior witnesses. This statute, this proposed statute, is about conduct. It's about the employer using its power to force someone to listen on pain of insubordination. The National Labor Relations Act prohibits a different kind of misconduct by employers, but it does not prohibit an employer from, regardless of whether the speech is virulently anti-union or, as a prior witness said, anti-abortion or pro-abortion or whatever. The National Labor Relations Act has nothing to say about the employer using its, what is sadly still talked about as property rights, to force employees to remain in that cafeteria or office and listen to whatever the employer has to say. That is not prohibited by the National Labor Relations Act.
Merely talking about, and you keep on expanding it, I've asked this a few times, the employer, all they're talking about is unions are bad, and you can clip that out if you want. But union, that's the message being right from employer to employee. And if you guys unionize, we're going to have a negative impact, and people are going to lose their jobs. That is coercive against employees associating in a union activity.
So you're getting close to crossing the line to what might be actually something National Labor Relations Act police. So the employer's forcing me into a cafeteria or wherever to listen to his opinion about why unions are bad, not an NLRA issue. If the employer then goes on and says something to the effect of, and if you join a union, I will fire you. Now you've gone to something that the NLRA prohibits. But this bill is simply about the forcing me into the cafeteria, regardless of whether it's pro or anti-union, pro or anti-abortion, pro or anti-religion, pro or anti-politics. It's got nothing to do with work. You're using the power the state has given you to force me into something which we think is fundamentally undemocratic. And the General Assembly has the right, and I think the responsibility, to decide it's time that master servant law be a thing of the past. We need to move beyond that. We have a different kind of democracy now.
Well,
or we should.
Well, we don't need to get that far down the road, but I guess the concern is that the determination that the conversation is violative is subjective. So, one could make a statement in a meeting like this, let's say that State of the Union address made me want to throw up. It's a political statement, right? Could the employee get out of the meeting and leave under this language?
So if that's clearly a political statement, I think we would agree on that. What the bill says is if the primary purpose of the meeting is to convey the employer's views on politics, et cetera, then the employee would have the right to leave. And all the employer has to do in order to protect themselves from this bill that CBA seemed to express such concern about is just don't fire the worker. That's it. Don't fire the worker. Don't threaten the worker.
How does the worker know? So now that statement is made, worker opts to leave.
Okay.
How does the worker then know that they're leaving the meeting is justifiable? Because the meeting could go one of two ways. It could from then talk about the income of the business, new things that are happening in the business, or it could talk about the reasons why the State of the Union address made the individual want to throw up, right? It would be the intent of this language to deal with that. But at that point, the employee has left the room. So how does one tell?
I'm not sure exactly how to answer that question. So right now, if the employee's been directed to be in the room, right now the employee has no protection, no matter how much the speech is anathema. And you could come up with something more anathema, far more. I wonder if anathema is a verb. But anyway, far more offensive than what you've just said. The employee has no right at all. This statute gives the employee some rights. Nothing is perfect, and I would do a lot to, like, if I could wave a magic wand, I'd do a lot to change the nature of the workplaces in Connecticut. But this is the General Assembly making a significant step forward by taking a position in which employees are in a fundamentally undemocratic position with respect to the employer power to force us to listen to speech and to give us some rights. That's a good thing. That's a good thing. It's not everything. It's a good thing, though.
Understood. But we're also inserting ourselves into the workplace. So now the statement is made, the employee decides to leave, and the employee is fired. So, because the meeting was going to be about how the company's doing, what great things the company's going to have, but this employee decided under this law that one sentence was political and opted. They have no idea what the meeting in its totality is going to be about. That is the problem with this. If anything, you'd have it actionable after the meeting.
So that
after
sounds
the
like
message.
That sounds like you would suggest we make the bill stronger and remove the word primary purpose and simply give the employee to write whatever, to leave whenever a speech contains anything which has any social, political, or political content. That might be a bill for another time, some years down the road. You know, from the perspective of someone who has no rights in this situation, having some rights in this situation is a big step forward. And I think a lot of witnesses talk about how it felt to be in that situation and to feel powerless. It's not something that any of us should be subject to. And again, it is regardless of whether or not the speech is about a union or about politics or about, you know, difficult issues like pro or anti-abortion. But those are all tough things that, as you know, American citizens, we're proud that we don't have to listen to if we don't want to, except if I happen to be your worker. And then you're telling me maybe you're going to fire me because I don't want to listen to it. And this bill says that ain't right. That's all.
And I don't agree that with your scenario of making it tougher, but a lot of the stuff that I've heard today is actionable, I think. You know, we just heard about it. The young lady told us where people were given certain benefits, training based upon their race. I think that's actionable at a certain level. So I don't know how this would help this, but yeah, I've heard a lot of things today. But, always nice to see you, and thank you, Mr. Chairman.
You, Representative Porter.
Thank you, Mr. Chair, and thank you, Mr. Livingston, for your testimony today. I'm not going to ask your take on this because we've actually heard a lot of testimony from workers who have experienced this or are currently experiencing this. And actually, I take their word for what they're saying. I believe their lived experience. And I want to go back to, do you believe your understanding of this legislation to be that this would hinder employers from being able to, because the person before you said, you know, they wouldn't have been able to communicate during the pandemic around, you know, masks and this and that. Would this legislation as written impede an employer's ability to communicate with his workers things that relate to the job?
No. So first of all, the comments that were made by the CBIA see this bill as restricting communication. There's no restriction on communication at all in this bill, only on action, and the action is, you know, discharging or disciplining workers. And so no, you can communicate. The idea that the only reason workers ever listen to their boss is that they're going to get fired if they don't listen. I don't know where that comes from. The employer could call meetings, things that are related to work, like most of the examples you just gave, really have nothing to do with this bill. Of course, you can be required to listen to that. But other things that are not related, that are political or social matters, the employer can communicate them all they want. They are not restricted by this bill. So you can take the most unrelated to work thing you want. You can still ask your workers to come in and listen. You just can't, you know, discipline them when they refuse. That's all.
Right. Thank you for that clarity. And then there's a lot of implication around, you know, laws on the books and what's actionable. And I think, you know, you doing the work that you do, can you speak to what happens when, you know, people, and especially the people that have come before us today, you know, let's first be frank about who's being impacted. Majority Black and brown, majority women. So we're talking about folks that are really being subjected to a master servant law in more ways than one.
That's right.
And when we talk about actionable, what does actionable look like when someone that looks like me decides that they want to, you know, stand up for their rights?
So, you know, I think that's a good question, and it gets to what Representative Fishbein, I think, asked about. Didn't quite form it into a question, but sure, there are you know, this is about power. There are lots of different bills or laws that are designed to give workers some protection from some actions in the workplace. Race discrimination in the workplace is already illegal. And so when you know, we use the power, an employer uses the power given to them to force people to listen to speeches, and the people subjected to that power are more likely to be people of color are more likely to be women, et cetera. That makes it worse. And if we could prove that the employer deliberately chose to do something because of the person's race or gender, et cetera, that's already prohibited. But what isn't prohibited right now is the forced listening, which is undemocratic no matter what your race, creed, color, or gender, but particularly worse when it's inflicted on people who are further from the sources of power. We can fix that with this bill, and the idea that the previous testimony from CBIA that the NLRB is the only entity that regulates the transactions in the workplace. I mean, we have the Connecticut Commission on Human Rights and Opportunities. We have the Labor Department with wage and hour bills. We have health and safety regulation by OSHA. There are many, many different entities that regulate the workplace. But the one thing so far, for whatever reason we haven't touched, is we still force workers to give up their rights, not to be forced to listen to things that have nothing to do with work. We force them to give up those rights at the door. And that ought to stop, particularly ought to stop because it exacerbates long-standing, race and gender and other forms of discrimination, but it ought to stop. It's just not right.
I agree, Mr. Livingston, and I tell you, this pandemic has exacerbated a lot of inequities in our system, and this seems to be sounding a large alarm. And I hope that what we're hearing here today during this public testimony time will be, really, it will resonate, that our ears will be clear and we can hear what the people are expressing and what they're going through, with the expectation that we're going to do something about it. And I think this bill addresses it in quite an equitable way. So thank you again for your testimony. And thank you, Mr. Chair, for the time.
Senator Haskell.
Thank you so much, Mr. Chair. And Representative Porter asked nearly the exact question I wanted to ask. So I'll be very brief and just follow up on one particular point, which is that the frustrating thing about this format is there isn't a lot of opportunity to hear, arguments both for and against interact with one another. So I did want to give you an opportunity to respond specifically to the notion that including the words legislation and regulation in this bill would somehow prohibit an employer from discussing not just let's move away from the pandemic. I was really proud, and Representative Porter, of course, was a leader on making sure that there's a paid family and medical leave program. Would it be possible for an employer to have a mandatory meeting, the primary purpose of which is to communicate with his or her employees about this new program that's available? And I want to mention that I support this legislation wholeheartedly. I just want to make sure we get it right and that employees have an opportunity to learn about these important state programs.
So the answer is, first of all, any mandatory meeting required by law is required by law, and so the employer will hold it and can hold it. And to the extent that the employer is explaining a statutory or regulatory requirement, clearly that connects to the employee's work. That is not, this law doesn't implicate that. It's not intended to implicate that. If someone is concerned that the use of the word regulatory or whatever in the bill it somehow chills employer speech, again, the employer is always free not to fire somebody. So I suppose if you called someone in, let's say the Connecticut General Assembly were to pass a law, requiring employers to let employees know about their rights to reproductive freedom and the fact that it's contained within a health plan, which might be a good idea. But but there's some concern. So the employer calls the meeting. If it's not mandated to call the meeting, but there is in fact that aspect of the law that the employer is interested in explaining. All the employer needs to do, if it's even a close question, is simply not fire. If the worker then says, you know what, I'm uncomfortable with this and leaves, don't fire the worker. I mean, that's really to the idea that we are repressing employers in any way by this law. If it's even a close question, just don't fire them. But in the example you gave, I don't see that as a close question.
That's really helpful, and I based on that answer, I feel even more strongly in support of the bill. So thank you for your time, Mr. Livingston, and thank you, Mr. Chair, for the indulgence.
Thank you, Representative O'Day.
Thank you, Mr. Chair, and thank you, Mr. Livingston, for your testimony. Just real quick, I'm just trying to see how our brown and black folks more impacted if this legislation doesn't pass? Just from an educational standpoint, I was wondering how is that? Why is that?
So, we have obviously a society that where people of color are more likely to be in, for instance, service sector jobs. We have for 400 years made it, easier for people who are white and male to advance to, professional positions where they have more equal power and authority to employers. It's not the same, but they have more ways of protecting themselves. So more of the people who are at more risk from employer authority, in terms of proportions, you're going to see more people of color in the organizing drives I'm aware of. Often it doesn't. I mean, there are plenty of white males, but people of color are more likely in our society to be in the lower paid jobs. That's an effect of systemic racism for many years. So that's I think what we're talking about, and whether being subjected to anti-union speech or any other use of employer power, if you have less power inherently in a society after years of systemic racism, you're more at risk from abuse of employer power. So I think that's what you're hearing.
Gotcha. All right. So, but from a pure, as opposed to proportion, from a pure numbers standpoint, there are more disadvantaged people in the service industry. I mean, it's just not just black and brown. This is going to help theoretically. This is going to help everybody that's in every union employee in the service, or every service employee person, not just black and brown. This is, and frankly, as a pure numbers, there's more white males and more white disadvantaged as a pure numbers that would be arguably impacted in a good way by this legislation than there are black and brown as a pure numbers. Is that true?
I think both of the points you made are important. It is particularly bad that we see a disparity of power that impacts more proportionally on people of color and women. To me, that makes it worse. But it is also true that if you look at raw numbers, in many circumstances, I mean, one of Dr. King's famous observations was that when we fight to defend poor people, there may, at least at that point in our society, there certainly were more poor white people than there were poor black people. The proportions were different. And yes, there is a unity of interest in people who are struggling economically and from disproportionate power with the employer, whatever the color of their skin or their race, gender. But I do think that there's a particular poignance and unfairness when it reinforces, systemic racism, systemic sexism. That makes it particularly bad. They're both bad, but it makes it particularly bad in that, to me.
Thank you very much. Thank you for your testimony.
Further questions or comments? If not, Mr. Livingston, thanks for being with us today.
Thank you.
John Brady will be next.
Yes, thank you. Good afternoon. Thank you for this opportunity. My name is John Brady. I'm a registered nurse, and I'm the Executive Vice President of AFD Connecticut. I come to you today in support of SB 163, an act protecting employee freedom of speech and conscience. I did submit written testimony, so I'll summarize it. Nurses are taught in nursing school that our overriding duty is to advocate for our patients. And sometimes this can be difficult. And it is almost impossible if a nurse is afraid to use their voice in the workplace. This is the reason why the nurses at Bacchus Hospital decided to stand together and unionize in 2012. I was involved in that organizing drive, and I was the victim of several captive audience meetings. So I speak from personal experience how intimidating they can be. Management holds all the power in the workplace. Failure to comply with a directive can mean discipline, discharge, loss of income and security, not only for the employee, but also for their family. It's truer than ever in healthcare, where consolidation means being blacklisted at one hospital in a chain means you're blacklisted at all the hospitals in the chain. I faced several captive audience meetings during our campaign, usually one-on-one, one manager and me. Each meeting required me to debrief afterwards with my union organizer, much as I would with other nurses after a traumatic case in the emergency room, such as the death of an infant. The emotional strain was similar. In fact, that is the desired effect, to intimidate workers. My worst meeting involved not one, but two managers cornering me in a 10-foot by 10-foot supply closet while they took turns berating me for doing my, quote, union work. The managers blocked access to the door, and I had my back up against the opposite wall. At one point, someone stuck their head in the supply room, opened the door to try to get some supplies, and they slowly backed out without getting the supplies. And they told me later that you could have cut the air with a knife. It was so tense. This experience shook me for some time. Even after debriefing with my organizer, it was several weeks before I felt comfortable entering that supply closet again. No one should have to go through that. No one should have their constitutional rights to organize jeopardized in a way like this. No nurse should feel unable to advocate for their patients without fear of retribution. This bill would correct this horrible practice and protect the workers' rights. So I thank you. I thank you for your service to the people of Connecticut, and I ask for your support of SB 163.
Thank you, sir, and certainly thank you for all your work. Questions or comments from the committee? If not, appreciate being with us.
Thank you.
Barry Hawkins with us. Attorney Hawkins.
He is not going to be here.
Oh, okay. Judge Monroe.
Good afternoon. My name is Linda Monroe, and I'm here at the request of the Family Law Section Executive Committee of the CBA to speak against House Bill 5268. I appreciate the opportunity. This is an act that would require the payment of attorney's fees if someone is successful on contempt, and the payment of attorney's fees to the defending party if someone is not successful in contempt. And first blush, it seems like an appealing act, but it is really quite problematic. It robs judges of the discretion that they need in what is essentially a equitable proceeding. Contempts must be proven by a clear and convincing standard. Very often there is inappropriate conduct which would require a court to think about wanting to issue an order of attorney's fees, but it might not quite run to the clear and convincing standard. Also, as Attorney Conlon discussed, on the other hand, people cure contempts on the courthouse steps, and so a judge might not find contempt, but the party who was seeking the power of contempt would have been without, for instance, child support for a very long period of time till the moment of that hearing. So having this bill as it is now drafted takes discretion away from the trial court judge and may put parties in a very disadvantageous position. I don't think that was probably intended in the drafting. I, like Attorney Conlon, think that the drafting of this bill is likely the result of a lot of frustration that is coming from the current circumstances and the crisis in the family courts. And I suspect I was asked by our executive committee and leadership to speak to you today so that I could use my experience as a trial court judge for 20 years and chief administrative judge of family matters to answer any questions you might have that are behind the drafting of this bill. Thank you for the opportunity to speak.
Thank you, Judge. Thanks for being with us. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Judge. Nice to see you.
Nice to see you.
Judge, towards the end of your comments, you talked about the frustration and Attorney Conlon's statements regarding the current situation in our family courts. Did you have any suggestions as to, in your experience, how to get through those things that Attorney Conlon was talking about?
Well, I think I have some ideas. I mean, it's any of you who might know me don't think I come with a blank slate. In case management is something that I preoccupied about and gave a lot of thought to. One of the concerns I have is that the branch, in seeking to provide justice to litigants, has relied upon a system drafted by the National Center for State Courts that is really not well tested. And the literature that led to its current system suggests that the National Center for State Courts thought we should create a system that was, quote, good enough, but did not pursue excellence. And this can be found, by the way, if you want to read about it in the Family Law Quarterly. Most recently, there's an article about the crisis in our courts coming as a result of this pathway system. Unfortunately, it's not something Connecticut should be proud of, but it's now a national article. Our system that we had before, Representative Fishbein, and I know you know it because I saw you in the courts, it was imperfect, but people could file a motion and had a reliable opportunity to be heard within 2 to 3 weeks. Now that's not so. Not every motion is guaranteed to be heard, and when it might be heard is anyone's guess. So what we really have is a system that's created an unequal justice. If someone controls all the money, then they can wait out the person who doesn't have the money, who's desperate for the child support and the like. And frankly, in reverse, children are sometimes used as weapons, and they can be withheld with impunity. And that's why I think we saw this contempt motion come. We really should have probably a system that looks more like a hybrid of the new system and the old system. There needs to be procedural fairness. There needs to be uniformity. Chief Justice Rogers did a beautiful job, I thought, in her uniformity commission in making sure that every litigant who came into the court, regardless where they were in Connecticut, whether it was in Bridgeport or Rockville, they would get the same system of justice. And that kind of uniformity really needs to be in the forefront. Procedural fairness requires a transparent system where people know that if they file a motion, it will get a hearing date and will be heard. And in fact, our Supreme Court, in the case of Ramin, requires that. But there is no guarantee of that now. So I think we have to go back and not throw out all the old principles, Representative Fishbein, but take the best of them and integrate it with some of the new processes.
And I'm sure if something was suggested that you'd be willing to be part of that process.
I would help as I can. I will point out, I do not appear in court. Many of the judges were our close friends, were colleagues, and I trained many of them. So I speak from an administrative knowledge, but I don't have my boots on the ground like Attorney Conlon does.
Understood. Well, thank you. And thank you, Judge, for coming before us today.
My pleasure.
Further questions or comments from the committee? If not, Judge Monroe, good seeing you.
Nice seeing you too. Thank you.
Have a nice weekend.
You too. Bye.
All right, let me call the rest of the list here. Shirley Pripstein, Emma Vasquez, Madam Administrator, anyone left in the waiting room to testify?
No one else is left.
All right, well, with that, I will declare this public hearing closed and wish everyone a nice weekend. We will see you all on Monday for another adventurous day in the public hearing. What do we have? What do we have Monday, Madam Administrator?
We don't have anything Wednesday.
We don't have anything Monday. Okay, so Monday's an off day, which is good because I'm in court on Monday all day. So we will see you all Wednesday for what type of bills we're doing Wednesday, Madam Administrator?
Police and prosecutor.
Police and prosecutor bills Wednesday. So we will see you all back here then. All right, have a good week.